How is Ken Ofori-Atta, the former finance minister, a fugitive from justice? How exactly? The OSP will explain. The Operation Recover All Loots says there is the potentially over 21 billion United States dollars that can be recovered from the work it has done so far. Analysts say, hold on, you just may get 12.5% of that, nothing more. But how? Does the regime pursue looters, quote unquote, at the same time discontinuing cases by looters in the courts? There's been mass sacking. Thousands have lost their jobs by the stroke of the pen of the chief of staff. The chief of staff would be acting on the orders of the president. Just 8 years ago, the president was complaining bitterly when he was not president about such mass dismissals. How do we resolve these last-minute recruitment rituals? We write back to deal with the vexed matters, but we can confirm two things for you. Ofori-Atta's house certainly was not raided by the OSP, but those who went there, did they go there under the power of law? We find that that may be the case, an arrest warrant. But that still leads us to some confusion. The former Attorney General replies Dominic Ayine, particularly in claiming that discontinuing the case for the now Bank of Ghana governor was the best thing to do because the former Attorney General had a memo that recommended that he should be discharged, and he ignored it. Dominic Ayine has been challenged to produce that memo. That's the question on everybody's lips. We here at Newsfile have seen what is their memo, showing that Dominic Ayine quoted exactly from that memo. The memo of the 16th of November, 2023, is it? We'll be right back to deal with the vexed matters. Welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, as we always do, we put Ghana first, and we'll assure you that you will enjoy today's edition of the show, as you always do, and even better. My guest this morning, Frank Davis. He's chairman, Constitutional and Legal Affairs Committee of the New Patriotic Party. Of course, you know he's a lawyer. Bright Simmons is right here in the studio. He's honorary vice president of Imani Africa. Daniel Domelevo is former Auditor General, and he is also a member of the Operation Recover All Loot Committee. Samuel Apiadako is the director in charge of strategy, research, and communications at the Office of the Special Prosecutor. And Dr. Justice Stromsai is senior lecturer at the University of Ghana School of Law and Deputy Attorney General Designate. So get ready. Now, the OSP's announcement And the raid at Ken Ofori-Atta's home, the former finance minister, has brought up a lot of issues. First, let's go to Parliament and hear how the MPs feel this can be dealt with.
July 2017. AK-47 wielding corps raid John Jinapor's home. Mr. Speaker, 5 police officers believed to be from the National Security on Friday raided the home of former Deputy Power Minister, Mr. John Jinapor, in search of documents related to the controversial $550 Ameri deal. Mr. Speaker, this very house, this very house approved the Ameri deal. I thank you. Earlier on, I had tried to catch your attention. I think it's important we set the parameters right. Let it go into the records that nobody's afraid of this subject matter. And the leader says that he's cautioning. Nobody's afraid. Nobody has anything to hide. Now, the point I want to make is that, Speaker, yes, when we are debating, we make reference to other sources of information. Let it be put on record that any matter that anybody wants to reference, it should be tabled. It should be tabled. Speaker, if our colleague has some source of information, let that information be tabled before he can proceed on same subject matter. You can just get up and say that Ghana Web. Table it. Let him table it. No, he should table it. Anybody gets up and say Ghana Web, he should table it. We can insist. Let him table it. Then yes. We can take his source serious.
Honorable John Jinapor.
Mr. Speaker,
you've already spent 1 minute.
Mr. Speaker, that's most unfair. That's most unfair. I mean, you can't do this to me, Mr. Speaker. Mr. Speaker, you are a leader. And you should know that when something is public record, especially in this house, we do not tender any evidence. Professor Mike Okwe, then Speaker, made a ruling on the matter in this chamber. You were seated here. Professor Mike Okwe, Ofori-Atta wrote to the OSP that, look, I am not in the country. I've received the invitation and I will come back and report to you for any investigation. You have no right, Mr. Speaker, you have no right to send soldiers to raid a man's house when he's not there. When he has told you that I will come, I'm out of the country. It is worse than armed robbery. In fact, to the extent that I have seen pictures of Richard Japa, who has just been forgiven of his sins, raiding somebody else's house. What business has that man in the house of a man who is supposed to be traveled outside? This is not the democracy we are building.
Thank you.
It is wrong for John Mahama, who just won an election, to try to use soldiers to intimidate people.
Thank you very much.
We will not agree today.
Thank you very much.
We will not agree tomorrow. We are not cowards.
Thank you. Thank you.
We will account to anybody who wants us to account.
Thank you very much. Now,
28th July, Professor Michael Quay wrote to the CID in respect of this matter. And so what other evidence do you want me to tender when it's captured in the Hansard? Anything captured in the Hansard, you don't tender any evidence. Mr. Speaker, I am saying that on that fateful day, Mr. Speaker, on that fateful day, when my house was raided by AK-47 wielding national security operatives, when they banged on my door, creating fear and panic, sending my 6-year-old child into a state of hysteria, into a state of fear. We had members here. They never commented on it. And I commend Professor Michael Quay on that day when he stood up and ruled that what they were doing was wrong. Mr. Speaker, they took my phone, they took my laptops, and took it to the United Kingdom to investigate me. Today, a very simple matter. You are scared of it. Mr. Speaker, let me explain something. The OSC has declared Mr. Ken Ofori-Atta as a fugitive. As a fugitive. Mr. Speaker, in our local language, fugitive, in our local language, it means that wadenwa kamura. Or, to put it simply, wajibam. Or in the Hausa language, otilo. Or to put it in a more simpler way, ya gudu. It's as simple as that, Mr. Speaker. But Mr. Speaker, we should not be afraid of accountability. As public officials, when they took my laptop, it got to a point they couldn't even open the iPhone. I told them I was willing to come and use my fingerprint. It was then and there that they told me that the phones had been taken to the United Kingdom. I had to give them the password. Eventually, the very America that I was accused of, a minister was dismissed because it came here padded by almost $800 million. Mr. Speaker, on this auspicious day, on this day of reckoning, on this day of accountability, the only thing I can say is that we wish the man in white,
5 minutes.
the best of luck.
Is up.
But Mr. Speaker,
5 minutes is up.
The finance minister should come here and settle the scores as far as
5 minutes is up.
Military men led by Mr. Richard Jakpa unlawfully entered the premises of Mr. Ken Ofori-Atta, searched his rooms.
Honorable Minority Leader, the unlawful entry is by your own determination.
Mr. Speaker, you know that by virtue of where we sit, we are able to do some background check before we come here. I wouldn't want to mention names, but Mr. Speaker, when inquiry was made, it was obvious, and I state it for emphasis, that those officials from the state did not have any warrant. Mr. Speaker, we should not encourage such an approach. We should not. Our democracy is still young. Today, it is Ken Ofori-Atta. Tomorrow, it will be another person. Some of our colleagues should not forget that only yesterday, it took the intervention of certain prominent members of our side to ensure that they were not mistreated. We will not mention names. They know. So these should be the voices of reason on this occasion.
Several times there was a referral to a group known as a political class. And several times a call on members of the political class not to do this to each other. And what do we mean by let's not do this to each other? Let's not, when there is a change in government, try to hold each other accountable this way or that way. I take a position that, indeed, the reason why the voters go and vote for one political party as against the other is so that they will come and hold each other accountable. The day that we stop holding each other accountable, that will be the day the electorate will lose confidence in this democracy.
I signed a directive declaring a high-profile person a fugitive from justice. This person is wanted by the OSP to answer charges in respect of several cases, including the following. 1. contractual arrangements between Strategic Mobilization Ghana Limited and the Ghana Revenue Authority for the stated objective of the enhancement of revenue assurance in the downstream petroleum sector, upstream petroleum production, and minerals and metals resources value chain. 2. Termination of a distribution, loss reduction, and associated network improvement project contract between the Electricity Company of Ghana Limited and Beijing Xiaochen Technology BXC. 3. Procurement of contractors and materials and activities and payments in respect of the National Cathedral project. 4. Activities and payments in respect of a contract awarded by the Ministry of Health, initially commenced by the Ministry for Special Development Initiatives to Service Ghana Auto Group Limited for purchases and after-sales service and maintenance of 307 Mercedes-Benz Sprinter 305 CDI ambulances for the National Ambulance Service. And 5. Payments out of and utilization of the tax refund account of Ghana Revenue Authority. Ladies and gentlemen of the media, the fugitive's name is Kenneth Ofori-Atta. And this is to Mr. Ofori-Atta. You have two choices. You can either return to the jurisdiction voluntarily or the OSP will enforce your return. We are not without the milk of human kindness to appreciate and reckon a person's medical condition. But when you conduct yourself in a certain way to suggest that all you are doing is just a ruse and that you have no intention of returning to the jurisdiction, that is the conclusion we have come to. You see, as I said, the first communication to us was clear, that he was away indefinitely from the jurisdiction on medical grounds. Then we pushed further. You cannot tell us that you've gone out of the jurisdiction on medical grounds on your say-so. If you're a serious law enforcement agency, would you just take a person's declaration that, oh, I am so much an invalid that I'm unable to come? You demand to know more, right? And that is exactly what we did. So we pushed. The response that came was unconvincing. That he may, at some future time, undergo possible surgical procedure. And I said something which is very crucial. There's intelligence available to us, which we do not want to reveal now because it may compromise the investigation. That tells us that, and that's what I stated, that it is just a ruse, that he can travel to the jurisdiction. It's not as if he comes to the jurisdiction, we'll promptly lock him up and throw the key away. It is a process we go through. This is a democratic institution with very well prescribed constitutional and statutory legal processes.
So you heard in Parliament some of the members, including the leaders, taking the issues that have happened as regards Ken Ofori-Atta on very seriously. John Abdullahi Jinapor, the Minister for Energy, recounted similar experience that he suffered. We have heard Dr. Dominic Ayine, the Attorney General, also recounts similar experience in 2017, and James Ejenim Boateng also recounting similar experiences. Of course, these are not just tales that they are telling, they are truths that these things happened. I was lawyer for Kofi Adams, so I know these things. They did happen. They went to his home, took all his cars and locked them up, and they had to fight to get them back. And then Afenyo Marking was urging caution that the political class must not do this to each other, to themselves, that it is not good for them to be doing this to themselves. And then the majority leader disagreed, that he was proposing that they should not hold each other accountable. And he disagrees with that. Well, the majority leader later rendered an apology for how Ken Ofori-Atta's home was, quote-unquote, attacked. Questioning. Because it happened yesterday, it is okay today, but why is it happening today, and is it justified? Let's begin with Frank Davis. Frank Davis, thanks for joining us. Please unmute your mic. Okay, so we'll give Frank Davis some time.
Thank you very much, Samson.
Great.
Thank you very much, Samson. Thank you very much, and thanks for the opportunity. My greetings to all Ghanaians, descending Ghanaians, your viewers and esteemed listeners. Samson, I must say that the events of recent time have left all of us wondering whether we are pursuing any good democracy or constitutionally prescribed governance. I don't really understand why we are boxing ourselves in such despicable, excuse my language, situations. There are always laid down rules, procedures, and practices for doing things. So it falls short of trying to offer any whimper of excuse for things which ought to be done regularly and properly and are done otherwise, for people just to come back and apologize. What is wrong yesterday cannot be right today. And there is no need to make referrals to the past when the present is there to guide us. We look into the past and correct our mistakes, of the present. But when we still do things that are condemnable in the past, in the future, who is going to appease or hold himself responsible for what has happened? It is worrying. It is worrying, and I find it very difficult to appreciate and understand what is going on. If you take my circumstance as a trained lawyer, now this Ken Ofori-Atta matter, I am pained by the fact that, and please, nobody should wax political about these matters. We are talking as discerning Ghanaians, and I'm talking here as a lawyer, not as a political actor. So I am going strictly according to the dictates of law.
First, will it be wrong if they went to the house with a search warrant?
It should not be wrong if they went.
Warrant.
It should not be wrong if they went to the house with an arrest warrant. Of course, if they have an arrest warrant, they have every right to come to your home. But the decency is communication and notice. The decency is communication and notice. When we all know that the person being sought after is not a petty criminal, it's not a common criminal walking around the streets. This is a minister, or was a minister of state. For God's sake, the finance minister for that matter. A high-profile, very prominent cabinet minister. And where was Ofori-Atta until this? Was he not in this country? Was Ofori-Atta not in this country, but for the incidents of ailment, which was known practically to everyone? Who didn't know in this country that Ken Ofori-Atta was under some medical siege? If you have an arrest warrant and you come to my home and I'm indoor, the little understanding and limited knowledge of the law I have is that you politely invite me out and tell me that you have an arrest warrant to search my home. You have to exhibit the warrant. I have to see it before you enter. Something, you know. You have to exhibit the warrant to me. I have to peruse the warrant. under circumstances, I can tell you that, wait, yes, you have a warrant. Can I have the option of talking to my lawyer or something? If the decline is made, fine. But because arrest warrant is a process of law. So I have every right to interrogate whether even the arrest warrant is legal or regularly procured. So I can ask of you, the officer, that am I permitted to talk to my lawyer? Since this is a process of the law courts, you want to come and search my home. It has far-reaching implications for me.
In fact,
so can I consult my lawyer?
In fact, those seeking to arrest you are the ones supposed to read out your Miranda rights.
Of course, the Miranda rights
to tell you that you have the right to speak to a lawyer of your choice.
They have to read your Miranda rights to you. But in this country, everything is taken for granted. Okay? If they had a lawful arrest warrant, they should have gone through all this. But you don't just barge into somebody's home. I have seen what happened there, and it is traumatizing.
So
I mean, even if you want to set someone's home, you mean you don't have to even give the benefit, the person of the benefit of being there. What if you drop something there? If you want to search my bedroom, would you search my bedroom without me present in the bedroom? What if you go and drop something there? So and then you will be responsible for it.
As we understand, it was not a search exercise; it was an arrest exercise, and we are now learning that they went there duly authorized with an arrest warrant. But being that they are national security operatives, they will have powers of the police and may not even need an arrest warrant. Do you agree with that?
Samson, if you are security operatives, okay, and you don't even need a warrant. I disagree anyway. And you don't even need a warrant. The proper thing to do is to put the person on notice if you get to the premises. That's the most appropriate thing to do. Barring any circumstances, you have to politely notify the person, but you don't barge in because that is not your home. The privacy of anybody's home is guaranteed by the Constitution.
Correct. The
Constitution is the predominant and fundamental law of this country. Any other thing done should be subservient to the Constitution. So nobody can say...
the MPs were actually quoting Article 18, as you have just referenced, in Parliament, except they read and stopped without completing the particular provision, which makes an exception for a criminal process. That the privacy of your home and your correspondence, your property is protected from being invaded. But there's an exception.
Yes, but something, all I'm saying is that appropriately, take it or leave it, I'm saying that it should be the courtesy of notice.
Right.
I mean, even if you come to my home, politely, I mean, let me know because that is my home. Even if there are exceptions, you notify me of the reason why you were there. And then you enter. That is the most civil and polite thing to do. But let's come to the issue. I mean about Ken and the circumstances which even led to that. And let's link it with the OSP's pronouncements of the matter. In the first place, how can anybody appropriately describe Ken as a fugitive from justice? I mean, who is the fugitive from justice? The little criminal law I know is that there are 5 simple criteria to declare someone a fugitive from justice. Failing to appear upon invitation, refusing to obey a summons or a warrant, fleeing the jurisdiction, concealing or hiding himself, or eloping or jumping bail after charges are preferred against the person in court. These are the 5 salient points to guide the definition, as I understand, of a fugitive from justice. You are fleeing arrest, prosecution, or investigation. But from from everything that has gone on, the correspondence between the OSP and the lawyers of Ken Ofori-Atta, how? In what stretch of the imagination, can anybody describe such a person as a fugitive from justice? You have written to the person has responded to his lawyers, he has given an indication of where he is for medical treatment, there's an address of where he is in the United States of America. You have invited him to come to see you on the 10th of February. He says, look, I'm having consultations and engagements with my doctors. I'm not able to tell you definitively when I'm supposed to come to the country, so give me time. In any event, if you have any queries, consult my lawyers. But something, there is no law which binds any suspect to assist the prosecutor in investigations. This is basic. First principles, of criminal law. There is no law which says that a suspect in a case should assist the police in prosecutions. No. Prosecutions
that's why they have the right to silence.
Yes, the prosecutions are carried out at the instance of the prosecutorial authorities. So you have to investigate and charge me. I can decide to be lean on assistance. So then what? So because the person, even if granted that Ken Ofori-Atta does not even want to assist in the investigation, does that make him a fugitive from justice? You see, sometimes in our loud pronouncement.
But normally the suspect has to be taken in and they have to give their statement, their caution statements, right? Before they are charged. First principles. Okay, so I understand that we have a little of a problem with Frank Davis's line now, but let's see if we can get Samida Aku to answer a couple of these questions before I bring my guest here in the studio in. Samuel Apiadaku is with the OSP, Director, Strategy, Research and Communications. Thanks for joining us.
Thank you, Samson.
Great. The first question has been asked by Frank Davis, and many have asked that question. What is it? How can you come to declare Ken Ofori-Atta fugitive from justice? Has he run away? From your communications, it's a period of less than 20 days. So why are you declaring him wanted?
Thank you. To declare somebody wanted, there are reasons why you do so. One of them will be that the person is unwilling to appear before you. The person cannot be located. And when it has to do with extradition, which is a different matter, that's when you are going through trial and the person has run away. In our case, it is because the person is unwilling to appear before us.
The evidence doesn't show that. Convince us.
The evidence more than shows that. First of all, it has nothing to do with the frequency of correspondence. So it can even be just 2 correspondents. Everyone in Ghana is equal before the law. We do not have first-class citizens, second-class citizens. Ordinarily, when you are alleged to have committed an offense, and you are summoned by the police, you go to them. Sometimes, many citizens don't even get the chance to be given an invitation. The police just zooms in and arrest them because the police can arrest without a warrant on account that they have reasonable grounds that you have committed an offense or about to commit an offense. When you decide that you will not avail yourself, that is when they will go to court, get an arrest warrant, declare you wanted. If you go to the Ghana police website, the UCO website, the OSP website, several people, hundreds have been declared wanted. And there is nothing wrong in this country. Nobody is complaining, nothing. Now, let me come to the
Because first of all, those people cannot be found. It's difficult to trace them. Those people may be ordinary people. Their bona fide is difficult. Ken Ofori-Atta is that easy to find, isn't it?
If it was that easy, then he would have appeared before us. But let me go on to why we are so convinced that he needs to come and not when he wants to come. A lot of people have referenced the letters. Let me go through the chronology. The SP already did that, but let me do a little more. It was You see, the first letter they wrote to us to say that our client is undergoing medical treatment and that he is unavailable and that we can sit in. Our first response was that, are you, the lawyers, trying to tell us that you committed the alleged offense with him? And so suddenly, lawyers in this country can now sit in for a suspect. The confusion in the minds of people who are sympathetic or people who may not understand what is going on is that they are thinking that Mr. Ofori-Atta is a person of interest. In law enforcement, when we say you're a person of interest, we simply mean that we need you to provide us with some information. Then it will help us make a determination whether we think that you have a role to play or not. We were very specific in our letters to Mr. Ofori-Atta. We describe him as a suspect in our investigation. The OSP does investigation silently. And when we come out to say you're a suspect and we need you for specific reasons. One, it's possible that we want to place you under arrest so that we either decide whether to grant you bail or not to grant you bail in as you know, the rule 48 hours. We need to take your investigation caution statement. We need to take your fingerprints. There are some documents we need to do. We may be able to want to do an emergency search at some places based on what we know. And this can only be done with the person, not his lawyers, unless the lawyers are saying that they are part of those who allegedly committed the crime. And so we pointed it out to them. Then they go back and now realize that they need to now attach a letter from a doctor. So then they attach a letter from a doctor, and the doctor just tells us that, well, I'm attending to this person, he will do this, he will do that, there will be possible surgery, blah, blah. We get it. The point we are making is that the burden is on you to tell us when it is you can make yourself available, one, or that you are giving us cogent reasons that you are so sick, you cannot even sit in a flight for 10 minutes. Where you are not moving from one place to the other, having engagements, and that we have to hold on. If you're able to give us such a reason, we are reasonable people. Law enforcement people
but obviously from the correspondence, you didn't ask for that. They brought you evidence to show that he is unwell and is undergoing treatment. You simply choose not to believe the facts of that correspondence, and you call it purported medical letter.
Yes, and you can let your viewers see their letter because they put it out there. Remember, OSP doesn't put out such correspondence. They did. Now, if you read it, it's a letter from a doctor. It's not a medical report. And it's not about whether we believe or disbelieve. The burden is not on us to show, to now come to you and show and ask you why you can't fly, why you cannot do this. Remember, you have first said your lawyers should come. We have now intimated to you that your lawyers, unless they are agreeing that they committed the offense with you, then we can deal with them because of the processes we want to take you through. Now, you then now realize that per our questioning, you now decided to add a letter from a doctor, not a medical report. Viewers, there's a difference between a medical report and a letter.
Yeah, that's my question. That's my question. If that was not satisfactory, why don't you ask for it? And again, can we not stay to the fact that Ken Ofori-Atta is not an ordinary Ghanaian?
In the eyes of the law, there's nothing like an ordinary Ghanaian and a special Ghanaian. Remember,
there is. That is why people get self-recognizance bail and others cannot get bail on in their names. If I got into trouble today, I could just go to the police, mention my name, I could be given bail. I could go to court and I will not be asked to put anything forward because I am a public person. The ordinary person does not enjoy the same thing. So it is true, is it not?
No, it's not true. It's at the discretion of the investigator. I mean, they decide to accord you that respect. That is fair enough. And that's why we've accorded him enormous respect in terms of the processes that we've done. The point of disagreement, really, sometimes I'm asking myself, what's all this chaos that people are bringing around this matter? Is because Mr. Ofori-Atta has not been able to give us a specific time frame within which he will make himself available.
At least they mentioned to you that sometime in March, So fair treatment. Allow him until March. If he doesn't show up, then you zoom in on him.
No, there's nowhere in the letter that says March. It says post. It said there will be surgery, another post. It can even be November. It can be next year. That's
give him the benefit of the doubt.
It's not about benefit of the doubt. It's about we agreeing that I'm undergoing this process and that I'll be done by, say, March, as you said, and I will make myself available to you on April, between 1st to 10th April. Then you are being specific, or that you are telling me that you are so sick that you are unable to come. Now, let me tell you something. Are we in this country now saying that these things should be at the discretion of the suspect? And people have said that the suspect need not say anything and blah, blah. Of course, nobody is inviting Mr. Ofori-Atta because we are now coming to take his statement to investigate. No, we are telling you that we have come out and we said you're a suspect because we have done our investigations and we are convinced that you have a matter to answer. It is your right. You can even come to the police station and say, I don't have anything to say. But of course, we must still take you through the process. We must still take the things we want to take.
No, what Ghanaians are simply asking is some amount of fairness in treating people in a certain station in life. The same approach to Professor Frimpong Boateng, and people were unhappy about it. Okay, and the OSP said that he doesn't consecrate saints. And so if Ghanaians believe that Professor Frimpong Boateng is some saint, they will not treat him as one. The same approach here, and people are complaining. Just exercise some fairness in treating them. Is that too much to ask for a person of the stature of Ken Ofori-Atta, Sammy? And you have dealt with him in a period of less than 20 days.
It's not too much. But the people who argue that way are missing the point, because the point is not about fairness. If it's about fairness, we have been very fair. That is why we wrote to him. Not being fair is rather having somebody bring you down when he has not even had a correspondence with you. Mind you, some people have even suggested that we could have stopped him from traveling. And we have said that, on what basis do you want to stop somebody from traveling? Every Ghanaian is free to travel for medical treatment, whether in Ghana or abroad. In the same way, when a law enforcement demands your attendance, you are not going to say that it may inconvenience you, and so you are not able to come. But you have to then prove to us why you are not able to come. Are you so sick that you cannot fly? Or the issue has to do with the inconvenience of your originally planned schedule? That is the whole matter. We are saying that once you are able to give us cogent reasons, we will give you that opportunity. And we have done so to other people who are ordinary Ghanaians and not even people who are elites, as you have said. There is no cause for alarm. I think that the tag of being declared wanted is what is worrying people. How is a person declared wanted? You are declared wanted because there will be an arrest warrant because we are not finding you, and you are declared wanted.
But there are damning consequences to that. There are damning consequences to that for people who have spent years building their reputation, getting all the education they can get and building themselves up professionally. This damages them. You must agree that this damages them.
Of course, it may damage you, but the point is that the OSP has not said that he's guilty of anything. The OSP has said that he's a key suspect in a number of investigations it has conducted.
What do you lose if you say we are investigating him, we understand he's somewhere else, but we are not going to take that? What do you lose? Do you have to declare him wanted and a fugitive from justice?
Yes, we have to do that because that's the legal procedure you have to go through, because when we do that, it means that we are now prepared to bring you down. And to be able to bring you back to the country, we need to go through certain legal processes.
It's been argued by a number of lawyers, senior and former attorneys generals, that you could proceed without him. So what's the big deal?
It's not true. Sometimes some things even baffle me when we say such things. Remember that we need to complete the preliminary processes at the police station. If we had finished with that and he had been charged, we could proceed without him. But
in criminal process, we hear that somebody is at large. They are tried in absentia. Is that not the same thing?
When we say a person is at large during trial, it usually means that everything has been done and filed, and that the person is not attending to the court. At this stage, there are certain processes we need to take. Some people have even suggested that we should go and do it where he is. And I was even surprised that some sympathizers had even said that he's in UK, right? That was telling me that they didn't really know maybe where he was. But how do you go to a foreign land and begin to do investigations and other? It's not done. Our protocols does not allow us to do that. The OSP has done somewhere we did video conferencing, but these people were suspects. These people were persons of interest. Please give me a few seconds. They were persons of interest. In the Madame Cecilia Dapa case, there was a person of interest. And I've already explained the distinctions between the two. We just needed information to be sure whether we need to activate processes to bring her down or not. There was another case that we needed to go there because that person was half Ghanaian, either half Ghanaian, half another country. And the
John
country
Mohammed's brother, that's the example that has come up.
And the country was unwilling to bring down the person despite an Interpol red alert and all that.
The UK was unwilling to bring him. That's why you had to go there.
There were serious challenges because the notice was not being executed. And I don't need to disclose all these things because of sometimes the implication it has. And that if that nation permitted that we come there and do it whilst they are there for purposes of guarantee and not witch hunt and all that, that can also be arranged.
The argument has been made that the world has changed. It looks like you are far behind. Don't you know how to use virtual processes like we are using to interact with you this morning?
Exactly what I just told you, because he's a suspect. The things that we have to do, he needs to be physically present for us to do that. And it has nothing to do with virtual processes. We have virtual processes, but somebody is in your studio and I'm here. There are reasons why it is so. Now, when all is said and done, I've said that maybe the problem is with the fact that he's been declared wanted, but it's because we have also afforded him the opportunity to give us a time frame or to give us a cogent reason why he cannot be in Ghana.
You're looking for information with this person in the process. His lawyers say we are ready to supply you whatever you need. Why don't you take that to start with?
It's not information we are looking for. We have finished. We have done with our investigation. The OSP, and I'll give you a reason. You notice the former MPA boss. When his name was mentioned at a press conference, I saw a press release from him that had said that
Hamid.
He's not aware that he's being investigated. And I was saying to myself that, how on earth do you want to be aware that you are being investigated? Because he said that the OSP had not written to him. Of course, we're not going to write to you. We need to do our investigations on the quiet. Professor Frimpong Boateng, had it not been him who came out 3 months after we had interviewed him, no Ghanaian would have heard it. The time you would have heard was when we were ready. So all I'm trying to say that
I'm hearing a contradiction from you. Professor Frimpong Boateng came public. Otherwise, you would not have made it public. Here is someone that you have not even charged, and you've made it public.
No, the two are not the same. Remember I said that in the Professor Frimpong Boateng case, if he had not come out to say that, you wouldn't have known we are investigating him. And I was making the point to the...
We would have known. Your law requires you to make publications within certain periods, so we would have gotten to know.
Yeah, but sometimes we are not so specific or detailed, right? And that even feeds into my next action. Some people have complained. The OSP likes doing press conference. The OSP likes putting things out. The OSP likes doing that. And for us, we do appreciate all the concerns because we know that the OSP is new. Many lawyers will say, oh, they've read the OSP Act and all that, but sometimes, truly, they have not painstakingly gone through. They've not even read our LI.
Okay.
You look at the foundation of our law is that we are to be transparent in almost what we do. And our law allows us to even publish our investigative reports. Our law allows us to correct so many things.
So
how can you do these things in darkness?
Right. We actually meant to engage you briefly so you go off, but we would like you to stay on for a while for us if you don't mind. But you got it wrong when you said that Ken Ofori-Atta's the raiding of his home was staged or was an imposter action. Now we know it's a state-sanctioned process. It's national security sanctioned process. We are hearing that perhaps there must have been an arrest warrant, not a search warrant, for the purpose, and so they didn't go there to search, and all of that. We are hearing contradictions also, that he had actually alerted the Jubilee House long before he left the country. How the state security was unaware, that's another issue. So you got that wrong. You said that was your intelligence.
Let me first address the issue of alerting the Jubilee House. What has that got to do with us? The law enforcement agency has nothing to do with the fact that when you were traveling, you alerted either the former chief of staff or the present chief of staff and all that. We understand the courtesies and other things that are needed when you're in a foreign country and all that. Those processes has nothing to do with us. In the same way we have said that when people said that we could have stopped him from going, we said we can't stop him from going. But when we demand of his attendance, he needs to come down. So when we sent him the letter, yes, we are aware that he was out of the jurisdiction, but then we needed his attendance. The second point, a wicked lie was told against the OSP. And this is not the first time. You know, people try to paint a certain picture for you in this country in order to create chaos around you, create disbelief around you. And it's an old age trick that most people do. The night before the press conference, apologies of Mr. Ofori-Atta. Some of them are journalists, some of them are well-to-do and placed people in society. We're going round. And in fact, they placed it also the following day in a newspaper. And the newspaper had quoted, allegedly, the wife of Mr. Ofori-Atta saying that it was the OSP that stormed the house. Please, if you allow me to build this point quickly.
Yeah, be very quick about this. I need to move on here in the studio. Yeah.
But before they said that, they were aware the security agency that had entered the house. Mr. Adumotre on his show was ready to show pictures and videos, but did not do that. Because if he had done that, it would have exposed the lie that it was not the OSP. First of all, I'm happy that the OSP has been vindicated, that it did not go into the house of Mr. Ofori-Atta. And I don't even like to use the word rape.
The point I'm making is that you said that was...
yes, I'm coming to that.
Staged.
I'm coming to that. It's not
an imposter action. We know it wasn't staged, and it wasn't an imposter action.
At the time of the press conference, the intelligence that was available to the office had suggested that this was not carried out by the OSP, and at best, it would have been staged by Ofori-Atta or an imposter action.
Yeah, so you are a human institution. You can get it wrong. You got it wrong. Is that correct?
I'm coming. Upon hindsight, and I'm saying that if we had not pushed them, there was no way they would have come out and even display the videos and the pictures.
Okay,
remember, the timing is very important.
Thank you.
To allow me
thank you, Sammy. Thank you. Thank you. I need you to hold on there for me. Let me come here. And Frank Davis' line broke, and I think we can let's get to, okay. So Frank Davis, having heard Sammy Darko from the OSP, are you minded to, as it were, amend your position about what you, the NPP, and other Ghanaians, not only the NPP, say this is such an egregious, approach to Ken Ofori-Atta's situation?
Can you run me in a bit? I lost touch a bit before I came back. So what exactly did he say which is prompting what you're asking me?
The explanations he's giving, you spoke about when, someone could be declared as a fugitive. Your first issue is that when the person refuses to appear, he says, yes, that's the point. He's refusing to appear. And so they activated this process that they have activated.
But how can what he has just, I just listened to him, how can what he has said be a defense of what happened? I mean, if with the greatest of respect, if with the greatest of all respect to the young man, if this is how he communicates, then without giving with due deference and great respect to him, it's casting a very poor picture of the OSP's office. I mean, with great respect to him. All that he has says is laced with inherent contradictions and inconsistencies. He cannot make one simple point correctly. Now you ask them, look, Samson, when somebody fails to appear, what are the ingredients? You have written a letter to someone. Indeed, when that letter was written, the person was out of the jurisdiction. The person is minded, because he's out of the jurisdiction, to get his lawyers to respond to your letter. There is exchange of correspondence between you and the lawyers of the person. Whether he's a person of interest or he's a suspect is neither here nor there. There is a line of communication until the last bit that he said, look, I have medical conference with my doctors. They are examining me, and up to a certain point, I'll make myself available. Now, this man says that a letter from a medical officer is not a medical report. You ask him a pointed question. Why didn't they request for a medical report? If they were so minded, why didn't they request for a medical report?
He said that's not their business, and they are not interested. They had found that this was just an attempt to evade, and therefore they had to make a decision.
Samson, it wouldn't be their business, because that is a convenient excuse. In any event, the man has indicated that I have conferences with my doctors, and this is what my doctor has written. Whether you believe it or not is neither here nor there. But at least he has corresponded. So that cannot be suggestive of a failure to appear.
All right, please hold on.
Something. Yeah, much more. Please allow me this one. You know, when things happen, and with the benefit of hindsight, you realize that you are wrong, the most courteous thing to do is to apologize to the person involved. Now, your boss said it proudly and loudly at the press conference that the intel he has picked suggests that either Ken Ofori-Atta stage managed the raid on his home, or it was an imposter action. Now the facts have been laid bare. The majority in Parliament has apologized for what happened. The Office of the National Security has come out, and we are now faced with the bare facts that it was operatives of the National Security Coordinator who went to the premises. As a noble person, what are they supposed to do? He sits there to defend what has happened, that it was because of what they did that prompted what?
Thank you for that point.
I think you see, when these careless decisions are taken, they ought to be taken in context. You have embarrassed the man and told him that he has state managed a raid on his own home and put his wife and children in such trauma. And now that you have been exposed, instead of you to apologize, you are saying what?
All right, Bright, I don't know, how do you process what you have heard over the period since the visitation to Ofori-Atta's home and then the OSP's press conference?
So, I mean, is my mic working all right?
Yes, it is.
Okay, so, I mean, when your producer reached out and we're discussing, I was like, I don't have any specific insights into these matters. Like everybody else, I'm listening to the discussion in the media and the rest. And typically, we, from an Imani point of view, we tend to react when we have done our own research and we have specific insights to give. But there are a number of points that I can make. I was bewildered by the sequence of events because initially, as you've catalogued in terms of the narrative that we've seen so far, there was confusion whether or not the OSP had anything to do with it, and the OSP felt that they had to very strongly assert their lack of participation in this military raid, or so-called national security raid. Then the CCTV footage came. In fact, the first time I heard of this matter was on a WhatsApp group, which is a private WhatsApp group, where somebody mentioned that this incident had occurred, and that there was this suggestion that the military was involved. That, of course, was strange, because typically you have military raids if there is expectation of violence or terrorism, those kinds of incidents where potentially law enforcement agents, including the police, may be at risk because the people involved are armed or something like that. We don't typically mount military raids on civil targets. So that was confusing. Then eventually became quite clear that this was an operation that had had the involvement of either members in the National Security Secretariat or persons assigned to the National Security Coordinator. That one we get somebody in Parliament now apologizing on behalf of national security. And to me, everything seems completely disorganized. Is this authorized by the national security authorities or not? Because if it's authorized by the national security authorities, then why is the majority leader apologizing for their conduct?
Yeah, so now that is confirmed. This was a national security operation.
True.
So the majority leader clearly didn't get his information before he went apologizing.
Very, very strange. And everything has been strange right from the very beginning till now. Certain things are clearer, but we still have a lot of murkiness. I'll give you an example. When the famous declaration of fugitive status came, I quickly checked the list of wanted persons, and I realized that there were only 4 people that had been publicly declared as wanted by the OSP at present. I'm pretty sure they have had other declarations in the past. Sadia Hassan, Anthony Jesse, one Frank Asari, if the name is right. And my view of the matter then was that, this
they did for
process?
Charles Bisu also? Yeah.
Yes, but I think in terms of people that are currently, I think Derek Esman, Asumani, Frank Jesse, Anthony Asari, and Sadia Hassan. So I was assuming that perhaps the declaration was still in process. As in, this is not yet concluded, and at the time of the press conference, it was still underway. Now I understand that the OSP actually also has an arrest warrant, which is kind of interesting. And we have been told that, as you've just disclosed, the National Security also has an arrest warrant. So it does appear as if these are operations of the state, properly sanctioned. I have not seen the video that is being complained about because that could potentially change my view. If, as lawyer, the gentleman who just spoke, lawyer Frank Davis.
Frank Davis, yeah.
If, as he suggests, the conduct of these security agents were completely unacceptable, then of course we will have cause to be worried because even when you have an arrest warrant, etc., you are still required to be professional in your conduct, not to abuse the rights of suspects, etc. But so far, I think we are all literally just, trying to piece together a bewildering array of information, and it's very difficult to say one way or the other, conclusively whether somebody is at fault.
Interesting. The matters that the OSP is saying that Ken Ofori-Atta is being investigated for Strategic Mobilization Limited and the GRA. Strategic Mobilization, remember, it's SML. That became very topical. Manasseh Azore-Awini's investigations and civil society, particularly the ASEP, who did the work and unraveled wrongs that were going on in that area. You remember that this institution was asked to do an investigation around it by the president. They did, and they found a number of wrongs that had gone on with the process. They say there's the ECG and Beijing technology contract termination, the National Cathedral project. Remember the National Cathedral project, monies that were advanced without parliamentary oversight or some other breaches. Procurement of ambulances, you have heard about that. And they say the GRA's tax refund account payments. What's your understanding, perhaps in the general terms, about how serious these will be to warrant the OSP's posture, not to say, look, I want to give you all the space and work at your pace?
So for those specific ones, apart from the GRA matter, which I know nothing about, in each instance, there is documented fiscal waste, frightening levels of documented fiscal waste. The OSP, on that, to be entirely honest, the OSP's role and mandate is corruption enforcement, anti-corruption enforcement.
That's right.
So in Ghana, we define corruption pretty narrowly. It really is almost bribery and a few other things, abusing of public office for private benefit. I don't have specific evidence of bribery, and I don't have specific evidence that public office was abused in a particular manner. But what we do know from the work that we've done in respect of SML, the Beijing technology contract. I think that is the one that is related to what we now have with the smart meter, one of the earlier smart meter projects.
Okay.
The National Cathedral, we've been loud critics of the way in which money has been spent. The service auto issue is well known as well in terms of the ambulances. So these are areas where the Republic has lost hundreds of millions of dollars, literally. And is still, in some cases, still on the hook to lose even more money. Whether or not they amount to corruption and bribery is a matter that is entirely within the purview of the special prosecutor because it's provided no information whatsoever. Perhaps he could have given us a bit of a summary in each case why he thinks these are corruption and bribery matters. But from a financial management point of view, yes, we've had great concern with it. And of course, in most of these instances, you have multiple actors in the government, multiple civil servants, etc., etc. So if he's pinpointed the role of the finance minister, then perhaps he's suggesting that he's personally capable of facilitating some of these activities. We don't have the information. So it's really difficult. That's why I said I was really, really, really challenged talking about this particular situation when your producer reached out.
Okay, thank you very much. So the Deputy Attorney General designates. Why? Why are you laughing? You prefer to be referred to what you were up to yesterday at the University of Ghana, graduating students, many who are very excited about getting, various degrees, master's degrees in the School of Law. You can't hide. This is where you are now. So tell us, from where you sit, once again, let me ask you the same way I asked Bright Simmons. How do you process the issue of the raid of Ofori-Atta's home? And some say you cannot say raid, but I don't know. I don't want to state otherwise about that. Because you see the vehicles moving there, and you see the gentleman leading them step down, and the soldiers who are involved, or military attired, individuals also step down, and you see the gentleman pick his pistol, what appears to be a pistol, assisted by a military officer. Then he puts it in his pocket, appears to hide it, and then walks into the house. Gets into, a room, gets upstairs, gets into a room. We see people we understand are Ken Ofori-Atta's, household children. And then they come out somewhat. Then he looks at one or two things and turns back. Then we see them go out. We don't see them do a search, though. So from that to the OSP's pronouncements, how are you processing all that from where you sit?
Yeah, so I think certain things are clear now. They were not clear before. For example, we know that 2 state institutions are looking for the Honorable Ken Ofori-Atta. That is the National Security and then the Office of the Special Prosecutor. The second thing that is clear is that there are arrest warrants for him as well. Now, you and I have been working on these police military brutalities for some time now, and our position on these matters are well documented and are clear. The question, however, is what caused the agencies, the national security, to employ that kind of arrest? That we sitting outside may not know, because we know very well that there have been situations where national security have invited our clients and we accompany them to the national security. They will speak with them for as long as they want and we'll go. There have been situations where national security will stop people on the way and pick them up. There have been situations where they will go to their house the way you described. So perhaps what we need to understand, or what we need to look for at this point, is what really caused the national security to do that. Sitting outside, we may not be able to answer these particular questions. However, we also understand the pain that the relatives and the families of these persons have gone through. And if you were in their situation, and as some of the NDC MPs have narrated, it is not something that you can be proud of or you find pleasant. But the question still remains that we need to find out exactly what informed the national security to employ this particular strategy in going to the house. Now, the question about being a fugitive.
I've been trying to get information why they would do so, especially as we have become aware that Ken Ofori-Atta had delivered a letter to the Jubilee House about his absence before this happened. They are tight-lipped. They don't want to give any information except to say we went there on a proper authority for an arrest.
Yeah, so like Bright was saying earlier, these are details that we sitting outside will not be able to speak to, you know. Now, to the issue of being a fugitive, you know, I have had a client who could not be found in the middle of a trial. And I appreciate the processes that the police went through. And I believe you have had such instances as well. The key thing here is that is the person within the jurisdiction? And is there enough basis for the person's absence from the jurisdiction? And if, as the OSP is saying, they do not have or they do not believe that his excuses are enough to allow him to remain outside the jurisdiction, then I think that is what fugitive is about. If the law enforcement cannot find a person within the jurisdiction, and there's no reasonable or they don't find the reasons for the person's continuous absence from the jurisdiction satisfactory, they may have to engage or trigger other processes that may cause the person.
In Ken Ofori-Atta's situation, he's not within the jurisdiction, but there is reason. There is communication. There is evidence the OSP doesn't want to rely on.
Yes, so like I said, it is when the law enforcement authority find the evidence satisfactory, then they will say, okay, we can allow you so and so amount of time. And if we allow you this amount of time and you are still not showing up, then we can say, but from what the OSP is saying, he said there was a letter written that he's out of the jurisdiction for medical attention. There's no indication as to when the processes, the medical procedures or process will even happen. So it could be, in his own words, it could be November, it could be next year. The question is it also fair or right that the OSP would just sit down and wait for things to be done at the behest of the person they consider as a suspect? These are questions that the OSP could speak to. But if someone has any evidence...
They have spoken to that. They say, we don't want to go at his pace. This is our determination. He says he's sick. We have... The SP actually said, our intelligence suggests that he's not invalid, that he's able to get on a flight and get to Ghana. So either they said they gave him two options. Either he does that or they will enforce his attendance.
Yes, so either he does that or they will enforce attendance. These are the two options, and obviously this can only be the two options. My problem with the declaration is that to declare someone a fugitive is a serious matter. I mean, internationally. It will frustrate even your movement wherever you are. I don't know to what extent, apart from the press statement they have made, I don't know if they have moved on from there to trigger other processes. But to declare someone a fugitive is a very serious matter.
So he began the press statement and press conference by saying, ladies and gentlemen of the press, I have this morning issued a directive for ABCD for him.
Yes, so I'm saying that is a serious matter. And if it is found out later that there was not enough or sufficient basis for that action, I think other remedies must lie from that. And I believe that the Honorable Minister's lawyers are very competent enough to examine this and seek remedies from the OSP if this was done without sufficient basis.
Okay. So how about what is being said? Is it not true? Ken Ofori-Atta can come to Ghana today, show up at the OSP, and say, I'm not talking. He's entitled to do that, is he not?
He is, but he must come.
So what's the point?
No, I mean, he can say, and he has lawyers, the lawyers can say that, well, I am not interested in whatever you are doing, go ahead, and that can also happen. But until his lawyers or he himself comes to, he comes to say what you are saying he could say, the police will not sit down, or police processes will not say that because we can't find you, we will go ahead. In fact, to try someone in absentia is a very tall, order. By the Constitution, you don't just say because I've looked for you, I can't find you. You must publish some things. You must go through so many steps before you can start a trial, in absentia. So, if he believes that he doesn't want anything, he doesn't have anything to say, and he wants them to do whatever, which is his right. I mean, he's not bound like
that's right.
Frank Davis said, he's not bound to help the police. But the police cannot assume that by being out of the jurisdiction, you are saying that you won't help them. And in any case, they are not actually calling you to help them. It is part of the process. It's a process of fair hearing to make sure that every step of the way you are aware of what is going on, and they give you the opportunity to say what you have to say. And I think that is what this is about. It is not to compel him to come down, to come and help in that sense. It is just that if they don't invite him to come and he's not been given the platform to express his opinion, what it means is that then the trial will not be fair. Because you and I know that in the criminal process, every step, the accused must be involved or the suspect must be involved. And if you take the step without the involvement of the suspect, it could be a black point in the process, which could lead to the accused being what? Discharged. So if you don't give the person the fair hearing, you wouldn't know whether he wants to participate in the process or not. But it's entirely his right to do so. But when he's invited and he doesn't want to participate in the process, he can also state that clearly that I am not interested in this. I think this is not, that is it. But for now, he has not said so.
The facts that have come to your attention so far, do you think that Ken Ofori-Atta is being treated fairly?
I think when it comes to the declaration of his being a fugitive, I think from what the OSP has said, I believe there could have been a bit more of other steps before you declare such a person a fugitive. Being out of the jurisdiction and not being able to return within some time, and clearly from the letter, there's some willingness to participate in the process, and the period within which the communication took place, I think it's too short, and the tone of the communication, you could hardly say that the person is running away from justice. And I think that that could have been avoided. That could have been avoided in the process, but it has happened. And that's why I said
you
that...
fault their judgment when they say from everything they have pieced together, he simply doesn't want to come.
Well, they've told us the things they've pieced together, unless there's something that they've not told us. But from what they have told us so far, there is clear evidence. I mean, the letters we have seen, the OSP's own speech, and the period within which they have asked for him to come. And the reason for his not coming, which is medical. I don't think that the medical reports would be necessary at this point. Because if someone travels out of the country, okay, and is going for medical procedures or examination or whatever, and you don't expect him to publish the details of that to the OSP at this point. But that is why there could have been further communication or further engagements on the matter. Then you are sure that the person is really a fugitive, because to declare someone a fugitive, like I said, it's quite a serious matter. And
except that we don't know what intelligence they have. Is it unfair? Is it sufficient grounds? When they do you find that they appear to have sufficient ground to say his response suggests indeterminate situation, that, well, I don't know. I don't know when I'll be available. I don't know.
Maybe let me explain what it means to declare someone a fugitive. When you declare someone a fugitive, you are engaging the international community to help bring that person to justice at home. What it means is that other law enforcement agencies elsewhere are authorized to what? Apprehend the person and ship the person back home. And I'm saying that you cannot engage the international community in this regard based on the facts that they've put out. Well, if they have something which is not out, but which they took into account, then we can say that we are not aware. But from what they have said so far, I think that it is too harsh a decision to take at this point. Because, I mean, fugitive from justice is a serious matter. Let's accept that it
okay.
is.
All right. Thank you very much. So if Sami is still with us, we'll give you just a couple of minutes to round up so that you leave, having heard everybody and what they have said. And it does appear that the opinions cumulatively don't seem to suggest that you could have been a bit accommodating. What do you say?
Thank you very much. That's why I said that it depends. Usually when sometimes you are from outside, you may think something is not right. But the point we're trying to make is that there's a difference between a criminal fugitive and fugitive from justice. Sometimes we tend to use the words interchangeably, but they are not the same. A fugitive from justice is simply a term of art. Criminal fugitive is more serious than a fugitive from justice. A fugitive from justice simply means that you are not availing yourself to law enforcement agencies. So the point we have to make is that if Mr. Ofori-Atta is willing to give us a definitive date by which he wants to come to Ghana, the OSP is willing to accommodate that. Apart from that, if he's also able to tell us that he is invalid and cannot travel, the OSP is willing to accommodate that. What the OSP will not accommodate is to try and give some citizens the opportunity to remain where they want to be and do whatever they want to do without recourse to a serious alleged crime that we are investigating. That the OSP will not account.
Is it the OSP's investigation and intelligence that the longer it takes, there will be some dissipation of some funds, or that some of the evidences may be concealed, and that's why you need him immediately and urgently?
Samson, we have not even said we need him immediately and urgently. I think that people have not painstakingly listened to the SP. The SP has said that from your correspondence, you are unwilling to give us a date by which you want to come to Ghana. And from what your doctor wrote, your doctor has also not given us any reasonable grounds to believe that you cannot fly. It leaves us with only one conclusion, which is that you at this time, nothing we are doing concerns you. And as everybody has said, we are not saying that we need Mr. Ofori-Atta to come and give us evidence to be used against him. OSP has never said that, and the OSP will never do that. That's why we said that he has a right to say whether he wants to say anything. But the process must go on. The arrest has to happen. Things have to follow. And the last one has to do with a little clarification about the OSP stating that it's either staged or an imposter action. That had nothing to do with another security agency. So the OSP, under no circumstances, was trying to demean another security agency. The OSP was only responding to a wicked lie that had been thrown onto the OSP. And you see, if you allow wicked lie to thrive, it builds an opinion against you. Remember in the Cecilia Dapa case, these same persons had created an impression that the OSP had used Rambo style to go to a house and all that, when the OSP never did so. They had even said that the OSP sent media people into her house when the OSP never did so. They mistook the OSP filming the search together with the suspect, meaning that that film is for media. As for journalists waiting at your doorstep to capture you, that is not under the control of the OSP. As for journalists appearing at the OSP to want to capture you, that is not at the control of the OSP. The OSP protected her, and up to now, no journalist even saw her in the OSP vehicle. Nobody even saw whether we handcuff her or not. The only claim, if I may finish, the only claim was, so you see that when people start to label an organization with no factual basis, and then a second one has come as if the OSP has gone to raid, the response of the OSP is that, Mr. Ofori-Atta and your friends, we have not come to your house. And if what you have just done, because we knew that you know the people who had come to your house, but you never put it out there, and you allowed
from what has become bare, I think that
it's not about what has become bare.
I think that, you know, I was going to say politicians, like you are not a politician. Dr. Educhum sat on this platform 2 days ago and admitted that the numbers they churned out as people who had benefited from free SHS, 5 point something, was wrong, and that is 3 point something rather. And he was candid in admitting. And I think that's what the people are expecting from you. It does appear you are seeking to rationalize this, because when you say it is staged or imposter at best, and we find out that it wasn't staged and it's no imposter, you cannot say that, you know, people are making any claims that are not founded.
Samson,
in a minute, please, let's not continue on that tangent. In a minute, now the accusation is that, so what is this? You do all of this and in the end, you don't do anything. You haven't done any prosecution. You are just wasting money in that office and doing nothing. What will be your last response to that, quickly?
The OSP is one of the most functional law enforcement agencies that we have in this country. The OSP currently has a number of trials in Tamale, in Accra, in Kumasi. Just yesterday, charges were filed against 6 persons. The OSP has investigated key personalities in this country. The OSP has moved actions that have saved the country millions of cedis, from customs division of the GRA to suspension of contracts. Even the first special prosecutor managed to be able to derail a JAPA and all that. So if people sit down and say that the OSP has not been successful, that may not be true, especially when it comes to trials. The OSP's job is to place people before the law court. It is the duty of the court to convict or acquit. That is not within our jurisdiction. Again, the average criminal trial in Ghana is about 3 years, right? The OSP is in its 3rd year. So it may not be so reasonable to expect that by now so many people should be in jail. And ultimately, the job of the OSP is not always to prosecute. But when we realize that there's no evidence against people, we make sure that we do not proceed. And we have done this in the Airbus case. We have done this in the...
Thank you very much. Samuel Appiah Darko is Strategy and Communications and Research Director at the Special Prosecutor. And we'll take a quick break. And when we return, we're going to be asking questions because the former Attorney General is asking very serious questions about the claims put out by Dominic Ayine, particularly about a certain memo that Dominic Ayine alleges that Dame ignored and proceeded to continue the prosecution of the now governor of the Bank of Ghana. I began the show by reading to you. Let me read that to you again before we go on a break. A study of the facts of the case indicates, I'm not quoting from Dominic Ayine's presser or the press statement he issued. I'm quoting from the memo that Godfrey Dame says does not exist. That memo says, a study of the facts of the case indicates that the initial facility of 300 million Ghana cedis has been recovered, leaving 150 million outstanding. The office has confirmed from the Bank of Ghana through Mr. Alexander Tarr, PW2, that's Prosecution Witness 2, that the interest from the outstanding amount is presently being serviced by UMB Bank. Mr. Tarr also indicated that UMB has an amount of 150 million locked up with CBG. It is expected that when the said sum is released to UMB, the loan amount for which A3, that is accused person, the third accused person being Johnson Esiama, for which A3 was charged with causing financial loss, will be repaid to the Bank of Ghana. This therefore may render the charges proffered against A3 moot, leading to his discharge. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. Some of your messages. And this one says that Collins Little Tete, the disorganized nature of the raid and the conflicting narratives from the OSP and national security have eroded public confidence in the institutions tasked with fighting corruption. This could hinder the effectiveness of future investigations. Musa Abator says it's clear that Ken Ofori-Atta is avoiding accountability. If someone refuses to submit to due process, it is only right to declare him a fugitive and wanted. No one is above the law, and due process. Okay. No one is above the law, and accountability must be upheld for the sake of justice and transparency. KD says the OSP's excessive grandstanding during press conferences undermines the seriousness of the situation. His emotional posture erodes public trust and calls for a more professional approach to restore confidence in his office. Christopher says if NPP folks feel they should be treated differently from other Ghanaians, they treated NDC folks in this matter, and it was okay for them to do so. Suddenly, they know that someone is not following the laws that they conveniently ignored just recently. Prince Henry Ofori-Atta says if the former president, John Mahama, was investigated by the OSP and the NPP saw nothing wrong with it, why should Ken Ofori-Atta not be investigated? If Ken Ofori-Atta is above the laws of Ghana, is he above the laws of Ghana? Let us support the NDC government to give us the Ghana we all want. Nobody has said he should not be investigated. Abdullahi Pagla Issa says it is right that no one is above the law, including Ken Ofori-Atta, but the footage that showed the invasion of the Jakpa-led security team like thugs whisking his children out was the lowest ebb of democracy and must be condemned. Mauli Atashi says, I like the way Frank Davis speaks with soberness when they are at the receiving end of one so-called mistreatment by the system. Flip same, and you will hear him speak with venom in the name of accountability and allowing the system to work. And we are learning from the mistakes. You need to observe Frank Davis a lot more carefully, and you may see that there may be some difference. Tanko Osman says Frank Davis and their likes claim the events at Ofori-Atta's home were traumatic. Have they forgotten how Ken's economic decisions have claimed life, DDEP, etc.? Ken doesn't deserve any sympathy. Kwesi Sapong says, someone sanctioned that raid? How did Jakpa know that the OSP was intensifying its actions against Ken Ofori-Atta? Big question. Who sanctioned the raid? We must demand the truth, and those responsible for this unauthorized raid must be held accountable. And the many of you who are making the target Jakpa, there are others who are telling you that Jakpa is the same person who led the operations that led to busting, a situation in millions of, counterfeit money, dollars, and so on around the place. So allow him to do his job. And then there's someone also suggesting that OSP has an axe to grind with Ken Ofori-Atta, particularly Gabi. Okay, interesting comments there. But when I hear that, I say that may be good, because the understanding we have is that the SP was recommended by Gabi for appointment. So if today they don't see eye to eye, perhaps it is for our good. Perhaps it is for our good. All right. So now let's get to, let's get to oral before the nolly prosecutions, and they are together. So let's take them together. So oral, Operation Recover All Loot. It's saying that potentially they can recover 21.19 billion United States dollars. That's like, if we got that money, we won't go to the IMF for like how many years? Like 2 decades, we will not go back to the IMF. And what a country this will be. Well, those who are crunching the figures and looking at the data say, relax, take it easy. You may just recover some 12.5% of what you are looking at. On that note, let's begin with Bright Simmons.
So do you want me to start with the famous noli prosequi issues or the...
if that's how you wanted to start, I wanted you to look at oral into that.
Okay, yes. So you want me to, but you want to comment on
that's right.
At the same
that's
time.
right.
I think with oral, first and foremost, we have to be very clear that a lot of people in this country are excited about oral. And I think those political actors who've made it a habit to try and caricature it and make fun of it are not attuned to public sentiment. And I think on the MPP side in particular, there is tendency to be out of touch with public sentiment, and you have to watch it. Going into the campaign, I had occasion to listen to some of their most senior people talk about the fact that, Ghana is not Accra, and all this inflation talk is nonsense. And I'm like, do you know the actual regions that were suffering most from inflation? It was Savannah, was the number one. So sometimes it's not data informed, it's not data driven, and there's this out of touch attitude about some of these matters that I think doesn't serve the MPP well. But there are others as well. So my view is, first of all, oral is extremely popular. I know people who have said that they didn't buy into the entire NDC agenda, all this 24-hour economy and the rest of it. But if only the MPP will hold people accountable in Ghana and stem the flow of impunity, they'll be happy. So that's number one. Number two is we should treat oral as a matter of policy. We should think of it as a government policy. If it's a government policy, then measuring it effectively becomes critical. Because one of the big problems we have in policy making in this country is that we can't measure. So everybody throws their arms about, they do some PR, people get excited a little bit, then we forget about what exactly that they promised, and then we come back 4-year cycle, same thing all over again, wash, rinse, repeat. If it's a policy, then the starting point is what problem are we trying to solve? And are the instruments we've designed a good match for the problem we are trying to solve? And how do we know we are solving the problem? Which is why I thought it was important to try and set some targets. So when I said that, if they can prosecute 50% of the cases, if they can secure 50% convictions, if of those 50% are willing to plea bargain and through that effort, recoveries can be made, then to my mind, they've done well. I was not saying that I'm forecasting that they will be able to retrieve 12.5%. I was setting a stretch target. I was saying that the target for me, which will be a reasonable target, is that if there's $20.8 billion or $28.9 billion, I've also seen $21.1 billion in other documents, that they've set as the damage that have been caused to the country.
Officially, what they reported to the president was 21.19.
Good. But the confusion that I think has arisen is that some people think what they are saying is that you can recover all 21.1 or 20.8. What they were saying is that this is the damage that they estimate from these cases that they've examined. So the damage to the country, the fiscal damage to the country is not necessarily the recoverable target. So I'm trying to set up a recoverable target, knowing that that is a stretch target. Why do I say it's a stretch target? Because when you look at the list of cases themselves, you will discover that in most instances, the likelihood of recoverability is very low. So take the famous $4.5 billion from the National Service Secretariat
Authority.
That $4.5 billion is an estimate of harm. I don't have the methodology. What I do know, though, is that if you take all the budgets of the National Service Secretariat since it was founded to date, and you added all that, it will be $4.5 billion. It will be significantly less. If you take the 88,000 ghost names, it could be more. We don't know, right? Investigations have not been done. But the 88,000 that Forfeit State has identified, and I trust Forfeit State, and you multiply the income that these people, were earning, these ghosts were earning, and you come to, the region of about 1 billion cedis a year, and you say this has been going for maybe 3 years or whatever, 3 billion, you still don't come anywhere close to $4.5 billion, maybe 5% of that amount. If you take the COVID cases, or rather the COVID spending, where I think they are also estimating about $4 billion there, $1.5 billion, $1.5 billion thereabout. Most of that money, you saw it on the streets with all the free water, free electricity, food being thrown about, expenditure that was made or for Ghana Cares, which led to loans distributed randomly to all manner of people. Much of that money, we don't know if it's been covered. Ghana Enterprise Agency said they recovered some numbers. I'm trying to get the data. Nobody's giving it to me. But those monies have gone to a wide range of Ghanaians. My sense is that a lot of it was wasted. The fact that it was wasted does not otherwise mean, though, then you can use the criminal process to recover. And I think you, a lawyer, will understand this better than anybody else. To be able to recover through the criminal process, you must establish crime. Or at the very least, you must convince people that, as I gave this money as free water and electricity, I'm now so guilty. I'm going to put my hand in my own pocket and bring that money out. Think of the matter in relation to
National Cathedral.
National Cathedral is a bit more clear-cut in the sense that, the identifiable contractors, whether or not to be able to get the money out of them is another matter. But at least you could make the case that the money was ill-spent. I mean, we had the parliamentary process, which to me was inconclusive, about whether or not the contingency votes could be spent the way that they said it has been spent. Because my understanding, from a public financial management point of view, is that if you wanted to spend it in that way, the President, the Chief Justice, and the Speaker of Parliament should have agreed. We've not come to any conclusion whether or not. When you saw what happened in Parliament, it was a spectacle. Nothing much came out of that. We also know that, they've identified the Bank of Ghana quantitative easing as a problem. And they suggested that about $5 billion of the $80 billion cedis in spending was, in their minds, problematic. Yes, many of us have agreed that it's problematic. A lot of the inflationary cycle spirals that you saw came from that money printing episode. But whether or not, after that, having moved that money to banks, the banks having distributed that money through the country, people have spent it all over the place, you can actually use the criminal process to go to court and extract $5 million back. It's anybody's guess. So when I say it's a stretch target, it's because when you take these cases one after the other and you examine them, you recognize that recoverability will not be so easy. So 12.5% is not the forecast amount. 12.5% is the stretch target of how much of it they can get.
People who have, acquired lands that they say must cost between $700, as it were, $1 million instead of 500,000 Ghana cedis.
Good.
They would go to court and say, well, I acquired it through a due process.
Even if
so you're not going to get that money from them.
Even if you get it back, it's still real estate. It's not cash in the pocket of the government.
Okay.
You restore back to the government's real estate bank, properties that have been alienated from the state. But that is not cash. That's not money you can just simply spend.
Okay.
So when you do all the analysis and you go through each of those cases one after the other, you conclude that setting a 12.5% recoverability target is actually a stretch target.
Okay.
Then you go to the next level of the analysis and you say, okay, most of us agree that this $21 billion they've identified is money probably not well spent. That raises a concern about waste massively, because $20 billion, as you rightly pointed out, is today nearly 30% of our GDP. And it's what? 7 times or 6 times at the very least the amount of money that we are, the IMF, begging, to be disbursed to us. We've had instances where we've had to do domestic debt restructuring, etc. Because the IMF said, if you don't do that, I'm not going to give you a $3 billion loan over 3 years. $3 billion over 3 years. And then we have instances like this SML thing where they are budgeting about $3 billion. We know about $150 million have been, $140 million thereabout have been paid. Why do we have a country that goes and does an IMF deal? And there are programs that could potentially cost this country $3 billion over a 20-year time frame. So we cannot talk about oral unless we are committed as a country to fix policies that are wasteful. And fixing policies that are wasteful is not done through the criminal process. Okay. It's done through public policy where all citizens start to become vigilant about the design of these programs, and where sometimes there are inherent structures within the programs that make them very difficult to deliver value for the people. Last critical point on the oral issue. We go back to this point that it has to be a policy. So we talk about the target, the measurability, etc. Transparency is going to be very critical. I have argued that in a lot of these instances, the problems are embedded in the actual policies that are being run in this country. If they are embedded in the very policies that are being run in this country and the NDC is not willing to start reforming those programs, then we know they are not going to get money back. We've been documenting instance after instance after instance of policies that are wasting money. They've now been in office about a month. We need to see direction. SML, what exactly is the direction? Issues to do with Kelly GVG, what is the direction? Ghana card, people are not aware. Hundreds of millions of dollars is being spent on just national identity, where we have so many other priorities. All of these matters, we need clarity from the respective ministries and from the presidency, whether or not there is indeed a commitment. Then you have to think through the actual mechanics of delivering this outcome, this oral outcome. prosecution is going to be important, investigation is going to be important. 2,417 cases. Most people don't realize the scale of that. I'll give you an example. In 2021, the total number of prosecutions by the Attorney General was 894. The total number of investigations by OCAL was 143, of which they could only prosecute 19. The target for 2022 was 50 prosecutions out of 400 investigations. NACOC, which may come in again in a future discussion, they could not prosecute anybody in this country for about 3 years. So prosecutions are not an easy thing to mount. So if you have 2417 cases, you need to really execute a number of critical strategies. One, recognize that some of the law enforcement agencies are in different ministries. UCO reports to Attorney General, the police and the CID reports to the Minister of Interior, the NIB, formerly BNI, reports to the Minister of National Security. All of these are investigative bodies thrown around. The Attorney General Department has to have a mechanism for executing ORAL that gives it an interagency coordination mechanism, the ability to draw upon the investigative resource of the different agencies. Secondly, they have to tell us how they're going to do these prosecutions, because their current capacity does not allow them to do 2,417 prosecutions in 4 years. Additional. Not when you're doing criminal prosecution in total less than 900. And lastly, if ORAL fails, now it's very apparent to us that it will be the failure of the Attorney General's Department, because they've been saddled with the burden. So I think transparency, communication, stakeholder engagement, clarity about the strategy will be very essential, because we'll be blaming them. You know, if this target that I've set, it's not a target for them.
Yeah. So let me do this quickly, and let's be brief about this so we can come to the nollie prosequis and the withdrawals and the contradictions that we are beginning to see, and the complaint is coming up a lot about, because you see you are recovering all loots, and yet you are sort of, as it were, clearing all the looters. This is a tough job for your outfit. And as we understand from Dominic Ayine, this is your brief. And he suggests to you 3 years, is it NACOP, had not prosecuted one case. We are complaining about OSP and how much they are not doing. Attorney General has been doing certain cases for 8 years, no results, and they have been terminated.
Yeah, thank you very much, Samson. Even though we call it ORA, which means recover loot, the policy framework for that goes beyond recovery of the loot. Definitely the loot will be recovered, but the ORAL is designed to actually stop the loot in some respects. So we have stopping the loot, we have recovering the loot, and also to create some level of vigilance among the citizens. So that is another aspect of the ORAL, and that has significantly been achieved, because now within a few weeks, the number of citizens who have reported what they suspect to be loot or crimes is just amazing. So that is also part of the ORAL project. Now there is facilitation of what we call, investigation and prosecution. It's also part of the ORAL. Now, as we speak, the Attorney General is in the process of establishing what exactly Bright said, an interagency committee for investigating these cases that have come. Because the Attorney General has realized that if the institutions of security and intelligence agencies continue to work in isolation, in silos, there's no way we can do much. So that committee is going to be the fulcrum around which all the agencies are going to work. Now, and also there's an aspect of the ORAL which includes sensitizing the public. And it goes beyond the rhetoric of see something, say something. It is going to be a general education for the public that some things cannot be done. So, for example, the president has indicated that there is no way he's going to supervise his appointees acquiring properties that belong to the state. If you want to acquire property that belongs to the state, you probably have to resign and go and acquire it as a private person. That is enough education to the public that whenever you see that any person who is an appointee or is an exposed person who is acquiring certain state properties, you should know that it is wrong, it is against this government's policy, and you have to report it to whoever, or the nearest police station or wherever. And then the ultimate thing is that the oral is supposed to also punish. It's supposed to punish because there is no way, recovery is not the end of this. People must be made to pay in terms of criminal sanction the harm they have caused this country. And that is going to be pursued. Now, the next question is, how are we going to do this, considering the challenges that we have in the
Oral, after submitting their report to the president, have they been disbanded?
So they have not been disbanded in that sense of the word. So the oral program has, like I mentioned, has several aspects. So
what was a committee?
Yeah, what we saw was an interim committee to collate these complaints. And the committee served a good purpose because, most of the times people see these things, and even when they are bold enough to file a complaint, they file it in a manner that no one can work with. Because sometimes the complaint system with the police and the regular, they are not accommodating.
So oral is a project and not that committee.
No, it's not the committee. The committee is just the stage one, the preliminary stage of the oral. The oral is a long-term government, NDC government project, which contains the things that I've mentioned. So now the mechanisms of ensuring this, we have really appreciated the challenges with the criminal justice system. And in a few weeks to come, the Attorney General is going to outline some of the reforms that are going to happen. That certainly includes the tribunal system. The tribunal system is going to be restored in accordance with the Constitution so that we would be able to achieve these goals. And there's no doubt that the nation, Ghanaians, are interested in this because Ghanaians have seen over the years that the biggest problem we have is this loot system. So one of the mechanisms which the Attorney General will be outlining in a few days to come will be the tribunal system. There will be a bill which will be placed before Cabinet to restore the tribunal system. And we believe that will augment the system.
That can be another argument because that seems to suggest as if the courts are clogged and there's no space. That's why you want the tribunal system to add on and to take on this.
For all you know, it is because of the non-use of the tribunal system which has made the court even clogged. Because, you see, the Constitution was designed with institutions in place. Some way, somehow, political discretion has refused to use some of the institutions, thereby creating a disbalance. So we believe that if we activate that which has been lying dormant for years, it may augment the system. That is not to say that the system is something that cannot work, but it is part of the general justice.
You were supposed to give us a brief on this because we need to go to the next issue. And let me go to Frank Davis because as we understand, the NPP has raised issues about the conduct of oral. You say looters and you are making publications even before you have concluded investigations at the level of just taking information. You are doing things that predispose people to defamation. Now, listening to what is going on, Frank Davis, you have hope that oral is now getting into a properly, so to speak, legal framework to attempt to recover, make recoveries.
Thank you again, Samson, and good morning to my friend, whom you just told has the burden. Justice. Justice Trumsai, Deputy Attorney General Minister for Justice Designate. Is it?
Yes, he's listening to you.
Well, Justice, would you respond? Anyway, something. I didn't hear what you said. I don't know, but...
Oh, good morning, Senior.
Yes, Justice. I don't know, but I think I have taken very useful insights and very cogent education from Bright Simmons, and I'm glad for that. You see, we should put all this thing, this oral, whatever, into perspective. You see, not drum home huge expectations only to run into sand. I mean, for me, I don't have anything against oral. Initially, my complaint had to do with the constitutional backing and executive authority for oral. But that is gone. I mean, we don't have a sworn-in president and all that. So fine. But something, you see, there's a huge gap between gathering information and evidence. I mean, as trained lawyers, there's a huge gap between gathering information and evidence. The two stand apart, they don't stand together. You see, so when figures are being bandied about, I mean, look at the statistics and the education Bryce Simmons has offered about the prosecutions the Attorney General itself was able to conduct. IOCO, other investigative and prosecutorial agencies, what they have been able to do, even with their investigative mandate. And it falls short of general expectations. But that is a stark reality. So when ORA says we have taken 2,000 complaints and there's so much fanfare, noise, and what are complaints? Look, 1 million trillion complaints do not gravitate into evidence. You have to sift out.
A multitude of suspicions cannot constitute evidence.
Can never. You see, so I think we should hasten slowly. And now I read on BBC, it is gone haywire that Ghana stands the prospects of going to get 21 point something billion, not billion, no. Some say $1 billion, 21 point something billion. But something. We have civil trial and we have criminal trials. Even when somebody owes you money in court, something you know, you are a leg boot advocate. you are not one of those lawyers who sit in their offices and proclaim they are eminent jurists and eminent lawyers. You are a leg boot practitioner. You run in the court with all of us. Of late, some of us have given up for you to take over. But you know what you have to go through when even there's a simple order 14 proceedings and there's a challenge. You know what you have to go to prove that indeed somebody owes you money. So is it with criminal trials. The mere fact that you claim somebody has stolen money is not the end of it. The duty, cardinal, all time, is always on the prosecution to prove the guilt of the accused person beyond all reasonable doubts. The accused person has no leg to prove his innocence. You have to prove that I have stolen money or whatever criminal offense you charge me. Now, if these complaints are handed to the AG's office, this so-called 21.19 billion unspent recoverable money, Bryce Simmons, with his expertise in the field, says they can only recover 12.5% of that amount. Granted, let's take it that they'll be able to recover.
That's for him the stretch.
Yes, let's even take they can recover. How are they going to recover those monies? They will have to go to court. Now, with criminal prosecutions, with criminal trials, even if at the end of the day, the accused person is found guilty, and he doesn't have the money, he or she doesn't have the money, how are you going to recover? You see, a restitution order could be made, but the restitution order is contingent on whether or not the person has the funds.
Chasing a man
unless you can prove. How are you going to recover that money? And now we see. So you see, this twist with these complaints, whether they are civil in nature, they are criminal in nature, we don't know. But now, I am gratified by the fact that now the AG has been sworn, has been given his appointment of authority. Very soon, Swemsai will also go and get his appointment confirmed. And then the real work starts. But I don't shed any tear at all for justice. You okay. You know the conversations. Let me address him. You know the conversations I've had with you, Justice. You see where the real work is. Baby, you won't chop deputy attorney, now you chop him. Let me go see the work.
Yes, sir. let me bring in.
So I am for myself. When money is going to be recovered from the state, it's the economy of Ghana. Something. It is not me, Frank Davis.
Thank you.
So we are all happy.
All right.
But let us be ginger. Let us tread cautiously about the amounts we throw about.
Mr. Yao, Daniel Domelovo, thank you very much for joining us. And we'll make this very brief. It does look like this is such a tall order. And you have even had the cause to express some, I don't know how to call it. You said you'd be disappointed if this is not followed through, because you can see that it's potentially, you may not get anything out of this, right?
Well, good morning first to your listeners and viewers. I don't think so. I am very optimistic that something can be recovered or come out of the data or the information that is gathered. That is the reason why I said I'll be disappointed if we leave it at that point. I was listening to the submission of the previous, I don't know. However, I agree, and I don't think any of us have that this is a judgment that we are going to say. If this is just information we have now and a complete what is done. So if we have done this to a sub part, then they go. You know, we need a step in the way to lose, and I think that two ways recovery is difficult. But that's where we get, if we get where the court counts that this money will be collected, or this money has to collect, then we are happy. Even if we are not to collect, we should go to hold people at. Thank you.
You have said majority of the cases need auditing to confirm wrongdoing. And that makes people think, so what have we been up to?
The point I'm making is that we have not done any investigation. Based upon our audit, our mandate, we only collected claims that have come to us. Therefore, if we don't do an audit, and in some cases, investigation, I don't think we can establish a prima facie. But then, running into the situation where people say that it is recoverable, it is not recoverable, these are all opinions, and I think they are all entitled to their individual opinions.
Nonetheless, you are hopeful that this will take us somewhere, and it will take us closer to the 21 billion.
Exactly. In fact, to be honest with you, I saw like someone's figure, and I laughed, and I said, well, that can be the case, but just what we refer to as guessing, is guessing and estimate. Okay? It could be more, it could be less. And there are several other cases that have not even added to the 21 yet, which can increase or balloon the data twice or 3 times. It is also possible that after investigation, it may drop drastically. Being an auditor or an accountant, you know that your initial findings may be very different from your final conclusion. At times, what you see at the initial point is just the tip of the iceberg. Your final conclusion is multiples of it. It is also possible that at the end of it, what you found at the beginning is so huge, but at the end, it is something very little. But it is good to go the full haul or the full set just to give the assurance that people will be held accountable for their stewardship or for the use of public funds.
Okay. Thank you very much, Daniel Domlevo, former Auditor General, and he has been a member of the oral committee that did the gathering of the information. We need to move on, but Justice Ramsay wants to say something in a minute, quickly.
Yeah, I think the attitude of looking or trying to kind of ridicule the oral and make it look like one of the usual things must be discouraged. And that is because, you see, this project is something that comes from the heart of the Ghanaian. And we should all do what we can to make... We are not pursuing some political, sloganeering project. As I've said, the information that have been gathered have been brought to the Attorney General's department. The Attorney General is sifting through all this to make sure that the real facts are brought out. Then we can give a definite figure. For now, it is just estimate, but when you look at the record, you will know how much you are likely to prosecute for, how much you are likely to recover. So I think that rather than sit behind and try to ridicule the process, as has just been done, we should be ready to, believe in the desire of the Ghanaian and pursue it, which is contrary
we take a break and return to OCAL, Operation Clear All Loot. Manasseh introduced that, and some people are really angry. How dare you say that? But very interesting, isn't it? But Justice, always remember that the Auditor General's report every year throws up $1 billion or more, but we end up not really recovering anything. Occupy Ghana did an auditing of about 5 years of the Auditor General's report, and it showed that money stolen and money misused, cumulative, was in excess of about 3 times what we have gone to the IMF for. We'll be right back.
The decision to withdraw the charges against Mr. Johnson Pundit Asiama for the simple reason that in the course of my review of the cases, my attention was drawn to an internal memo prepared by the Prosecution Division of our department for the attention of the former Attorney General, the Honorable Godfrey Yeboah-Dame, which recommended that the charges against him be dropped. This is very significant. This is an internal memo prepared by professional prosecutors advising the Attorney General that the charges against our current Bank of Ghana, the governor of the Bank of Ghana, be dropped. Note that Mr. Johnson Pundit Asiama was charged with contravention of the Banking Act for granting a facility of 300 million cedis to Universal Merchant Bank and for causing financial loss to the state in the sum of 150 million Ghana cedis. The internal memo, which I just cited earlier, concluded as follows. This is very instructive. It says, a study of the facts of the case indicates that the initial facility of 300 million has been recovered, leaving 150 million outstanding. This office has confirmed from the Bank of Ghana, that is, the Attorney General's office has confirmed from the Bank of Ghana through Mr. Alexander Tarr, that is PW2, prosecution witness 2, that the interest from the outstanding amount is presently being serviced by UMB Bank. Mr. Tarr also indicated that UMB has an amount of 150 million locked up with CBG, that is Consolidated Bank Ghana. It is expected that when the said sum is released to UMB, the loan amount for which A3, that is Johnson Pundit Asiama, was charged with causing financial loss to the state will be repaid to the Bank of Ghana. This therefore may render the charges proffered against A3, that is Johnson Asiama, moot, leading to his discharge.
I speak from experience as the nation would note that Dr. Ayini and other leading figures in the NDC and the government of the day were counsel in many of the cases he has discontinued. I say that indeed it is not uncommon for defense counsel as Dr. Ayini and other NDC personalities were, looking at the same set of facts to come to different conclusions, informed by their varying understandings of the law and, of course, the undeniable political considerations they hold. However, I dare say that in taking decisions as monumental as withdrawing those cases, the only consideration has to be the national interest and not that of defense counsel. The analysis I make of the reasons advanced by Dr. Ayini will expose the questionable intent behind the withdrawal of the criminal cases. Dr. Ayini's unfounded allegation insinuating unethical conduct on my part in the conduct of the ambulance trial, Republic versus Kasser 2000 and 2 others, is highly disingenuous and rather, unfortunately, recaps the series of falsehoods persistently published by foot soldiers of the NDC and other uninformed members of society. I must say that I find it quite ironical for Dr. Ayini, who is the subject of disciplinary proceedings for professional misconduct, still pending at the General Legal Council, filed by the Honorable former Chief Justice himself, to accuse me of unethical conduct. In the interest of the nation, the case of professional misconduct pending against Dr. Ayini at the General Legal Council should have been determined before the parliamentary assessment of his suitability or otherwise, for the high office of the Attorney General and Minister for Justice of the Republic.
Right. So, Justice, what a contradiction. Perhaps before I hear from you, let's begin with Bright. What a contradiction. Ghanaians are asking, and that's a legitimate question, isn't it? Yeah. That you say, we want to recover all loot, and here you are, not allowing the court to prosecute, to try people, and you are clearing them.
So, I mean, yes, obviously everybody, took serious interest in these developments. I think the right way to approach it is to look at the decisions case by case, and at the same time to consider the general principles that you've pointed out. But I was surprised when I, saw the former Attorney General elevating the bar of governance to that height. Because you recall that when he was in office, we had occasion to call him the most partisan Attorney General that we've seen in our history, at least as far as my adult life. So I was very impressed that, he'd elevated the bar of governance so high. I remember in the Jason case, in the Saul case, the famous lack of representation case, the Atto forcing case, I had a lot of occasion to disagree with the way that he was conducting himself as Attorney General, because I felt he was being extremely partisan. But that, nonetheless, his intervention was very informational. And I think for that reason, that was very good. The only, low point was when he sought to suggest that the current Attorney General, because he has a case at the General Legal Council, is somewhat unfit for office. I think that was very unfair because for listeners that are not aware, they would assume that this was a matter that goes to his personal integrity. It's not at all. This was a political matter. He had expressed concerns about how the Supreme Court had conducted itself in the matter of the election petition. And that was the only reason he was dragged to the General Legal Council. It had nothing to do with his personal integrity whatsoever. And I think we need to make that point very clear. But to go back carefully and look at these matters clearly, we will have to start with some of the cases. And because we don't have time, I've selected only 5 of them so we can begin to, add some flesh to the skeleton. I agree.
5 of them is almost all of them. No, 7 cases in all.
7 cases in all.
Yeah.
Yes. No, I thought it was 20 cases.
No.
That they were working towards. Okay, anyway.
What they have done so far.
What they have done so far, okay, fine.
7.
I heard 20 from somewhere else, but I might be mistaken that they were working on 20 cases and the 7 had been just announced. But for the 5 cases that I have, I think the decision to stop the prosecution of Democracy was just brilliant. And if they go ahead and do the same for the treason trial, that everybody in Ghana, except themselves, are aware is a complete caricature of justice, that will also be brilliant. I also agree completely with our Atto forcing case because I investigated that matter myself as an independent analyst and looked carefully at it. I think it's one of the worst abuse of the prosecutorial discretion we've seen in this country. A use of a letter of credit is itself a risk management instrument. The reason you use a letter of credit is because there could be problems with the project or the purchase. And so if the conditions are not satisfied, money is not released. So if a finance minister signs off on a letter of credit, he's actually applying due diligence and applying prudence to then prosecute him when the subject matter experts in the ministry and the rest of who are directly responsible for making sure that those purchases were sound have been left off the hook makes no sense whatsoever.
Okay.
On the second matter,
that may not be the same as all the other cases because that one, you can say Atto forcing and his colleagues, they won the case.
Yes, they won on appeal.
Yes, they won.
Yes, on the submission of no
appeal.
case.
So the Attorney General is now in the Supreme Court, right? True. And that's where they have gone to withdraw.
They've withdrawn the case because I think it was an abuse of
appeal. The former Attorney General says he believes that case, they would have won it. They would have won the appeal.
That is, everybody has their opinion, right?
Okay.
Those of us as bystanders who had no stake in the game, I would have told you that forcing case should not have been brought at all. It was one of the worst I have seen. Anyway, on Saglemi, I have cause to agree in parts with the arguments he made. Some of the arguments that the current Attorney General presented just didn't hold water. I mean, if you said $200 million had been part of it had been spent building houses, and so to my mind, the $200 million charge was defective. The argument that the former Attorney General makes is very solid, which is that you should have just amended it and said this is the amount of money that I felt was still in play. I was also not happy that he only addressed, and this was actually the challenge, because on the one hand, everybody's praising the former Attorney General for being transparent and seeking to justify his decision making. But on the other hand, he was not very comprehensive. So in the Saglemi matter, for instance, there are 70 charges that were preferred against the former minister. He addressed one of them, which was basically the cause financial loss to the tune of $200 million based on wrongful application. What about the 6 other accused persons, including one former minister of Works and Housing, who is also, most people don't know this, implicated in the Pualugu Dam matter, and we don't fully know the details of his involvement. So I think that in that matter, the Attorney General could have been way more comprehensive. The current Attorney General could have been way more comprehensive, because it is actually difficult to understand how everybody in that case did not do anything wrong, including the contractor and these variations that were approved and the rest of it. Then on the issue of Johnson Sema, which is why I have the greatest disagreement with the former Attorney General. No, the former Attorney General.
Rather?
Yes, because these are matters that are not only legal matters. A lot of, in fact, everything here is generally public policy as well, because even the decision to prosecute or not to prosecute is not entirely legal. There are a lot of public policy considerations that go into it. But I think this matter was extremely interesting because in the banking and finance sector, it's not only the legal issues that are important. There are other issues around macro-fiscal stability, etc., that are important. The current Bank of Governor was executing policy that his colleagues in the Bank of Ghana agreed with. He was executing policy that they agreed with, which was that we should use the emergency liquidity program, the fund that we have to support banks that are in distress, not in distress, but are having liquidity challenges. We should use it to prevent banks from failing. There are 2 types of liquidity provisions in this respect. There is the emergency type that you use, which can extend to as much as 3 months. That is, we can give you the money as a bank as much as 3 months. Then you have the intraday, which is extremely critical, because the intraday means that if a bank is failing settlement, the central bank can step in to enable the overall processes in the financial system, the banking system, to continue flowing. Essentially, what happens is when you pay someone money, let's say you have a bank with, you have an account with one of the banks, let's say Bank A, and you are paying somebody in Bank C, there has to be a settlement process because the bank, it's not the same, the accounts are not held in the same bank. So it's not just a matter of moving ledgers. You need to typically have a central bank situation where they debit the accounts of the different banks. If at that moment, the bank that it's being debited doesn't have money in their settlement account, it can lead to payments being failed. And this can have serious distress elements across the entire financial system. So if because of all of these factors, a decision is made that we cannot allow contagion in the banking industry, so we'll give money to Unibank through UMB, because at that time Unibank, I think, did not qualify to receive it directly. And this was a matter approved as a matter of policy. How do you pick up one of them, the deputy governors, and then sue and then prosecute him? I think that was very difficult. Or the UT matter, where the former Attorney General suggested that because of single obligor, 460 million should now have been paid. I could not make head or tail of it.
Explain.
Because single obligor is in respect of the bank. You are prevented from giving too much of your money out to a single person because you are concentrating risk. But the central bank is not obliged to observe single obligor if you are giving liquidity assistance. You understand what I mean? If the central bank is giving liquidity assistance to a bank, what is the single obligor issue in there? So I struggled to understand what he meant, that it was in violation of single obligor limits when the central bank was giving money to UT Bank to the tune of 460 million cedis. If UT Bank was underhand, was giving all that money out, and you suggest that they were breaching single obligor limits, I will understand, but that will have nothing to do with the central bank. The argument that we've had so far is that the previous administration was lax when the asset quality review was done in 2015 and 2016, in not pursuing it further to hold some of the banks to account. And then all of us have had policy issues today. But remember that the law that is being used, which gave the Bank of Ghana all these powers that they exercised so liberally during the resolution, that law was passed in September 2016.
Correct.
Long after these matters had occurred. So the instruments were not available to the central bank to tackle the situation in the manner in which this new administration, or the one that followed them, their predecessors, were able to do. So to turn all these policy matters into a criminal indictment, I think was just bizarre, completely bizarre.
Okay.
And, on the issue of the memo, now I'm pretty sure Bank of Ghana, your station is going to publish it, so I need not comment on it because now we know that that was not correct. Where I think that the previous Attorney General or ex-Attorney General was correct is in the $5 million, the claim that Honorable Atta approved the $5 million. Because we do know on record that it was approved by the Chief Director. And we also know that at some point, there was even a consideration of charging the Chief Director for doing it without authorization of the Minister. So I'm not sure how they could make those kinds of mistakes. So that is the case by case. And what do I mean by all of this? All I'm trying to say is that we have to examine these matters on their merit, whether or not they were valid or not. And independent bystanders who are in the public policy space can make that comment. Right. On the last point, on the big issue of principle, my biggest challenge is on principle. Mm-hmm. Because on what basis have they selected 7 or 20 cases? We have hundreds of people on remand. Mm-hmm. Some of whom have been on remand for more than 5 years. I'll give you a very quick statistic. Around 2017, 2018, about 25% of all the prisoners we had in this country were remand prisoners. About 3,000. Do you know why we have only now about 995 today in remand? Justice for All program. There was a consistent policy that enabled amnesty to be applied. Mm. How do you determine upon coming to office within a week that so and so case is so urgent, is so egregious that I'm able as Attorney General to determine that as a matter of public policy we need to discontinue those cases? How did it come by the selection? And I think it would be very good if the Honorable Deputy Minister Designate walk us through how did they what was the filtering mechanism? Mm-hmm. Or is it all defense attorney petitions? Mm. If so, was that an open call so that other defense attorneys in this country can approach them? Because I think that baffled me. Secondly, even if there was a mechanism to enable fairness to be applied in this respect, on what basis then do we have a situation where for the same particular situation, an individual gets off and others who similar facts have been applied to their conduct don't get off? It gets very, very confusing. Right. So those are my concerns.
Thank you very much. And so you should be answering questions. And Dami had very, very critical questions for you to respond to, some of which, Bright Simmons agree with. Some of the issues that were raised by Dominic Ayine, there are many who agree that it makes sense. For example, the query that was made, and this is what Dami said: I must indicate that I find the line of thinking of Dr. Ayine that simply because an alleged loss to the state is recoverable after the offense has been committed or the charge filed, the offense of willfully causing financial loss is rendered invalid. Very strange and unsupportable. Also, an amount paid in violation of a law, when subsequently recovered, does not clear the person who gave the approval to be made of criminal wrongdoing in the first place.
Samson, first of all, let's agree that there is a vast difference between Godfrey Dami and Dr. Ayine. In terms of, I'm not talking of the fact that one has a PhD and one doesn't. That is not what I'm talking of. I'm talking of the very appreciation of personal liberty.
PhD is important. Some of us have run away from it. It's not an easy job.
Well, but that's not my point here.
Okay.
I mean, the very appreciation of personal liberty is important here. You and I have been on this criminal defense for some time. What goes into a person waking up every morning and coming to court, being called, cases being adjourned, the cost, you can't do anything because you have to be in court. I mean, we just talked about someone who has been declared as a fugitive, right? If you have respect for personal liberty, you will not sit and argue that, well, if you think that the person is innocent, why won't you allow him to go through the entire trial for him to be declared innocent? When you know, as a prosecutor, exercising your professional judgment, that this cannot lead to conviction. We're talking of
in that case, what happens to Jachi Kwesin? Because Chachuchi Kata says, this is my case, I want my client to prove his innocence, the Attorney General says, well, I left that one, but I wanted to file another prosecution.
Let me just continue from where I
wanted to discontinue that one.
Let me just continue from where I left off, and I answered that question. For example, you have a memo which has been given to you. I know the former Attorney General said that he never had any memo. That cannot be true because the records, and I will encourage you to apply under the right to information laws to the Attorney General's department. And you will see copiously that there is clear record of the Attorney General the former Attorney General, having been, served with a memo which clearly says that this case conviction cannot be possible. And yet, he gave comment on it. He was saying that he never gave comment.
He didn't say cannot, he said may.
Well, at the end of the day, he may. The context, if you put it in the context, he means that he cannot. Eventually, there's evidence that he had a memo, he minuted on it, and took decisions contrary to what the memo said. And what Dr. Anyenini was saying was that, look, there's no problem if you feel that you can override the DPP, but to deny that indication came to you in the first place when it did come to you is to be dishonest. And secondly, look, we are talking of one of the issues that the former Attorney General said was that the AG did not consult the president in taking the decision to what?
Before you get there, you say there was a memo, you minuted on it. Dami wants to know, what did he say when he minuted on it?
He denied that there was a memo. I think that is sufficient.
That's right.
As to what he said, that's why I said that you apply to the ministry.
There's something I have become familiar with,
okay,
and I've already shared with the members of the public.
Mm-hmm.
What I've become familiar with and information is that there was the shredding of a lot of documentation.
Indeed.
And that in the course of the shredding of the lot of documentation, it does appear that this particular memo either was shredded or was taken away. But there was a certain trail that has been traced to this memo.
Precisely.
And that's how come there is the one that I have seen and I have shared with the public.
Perhaps the denial...
The one that I have seen and shared with the public does not have minutes. It's not minuted.
The point I'm making is that there is evidence that such a memo exists. There's evidence that the memo was given to the Attorney General. There is evidence that he has responded he has minuted and he has responded to the memo.
The evidence that it exists, I have confirmed that.
So
my viewers.
As to that point, let's establish that
right.
He lied to the public when he said he was not aware of any such memo. That's what he said.
First, he said it does not exist. Then later, I think he was cautious and said if there was, nothing of the sort came to his attention.
And now all of them are false because it existed, it came to his attention, and he minuted on them and directed the DPP on what to do. And I'm saying that if you doubt what I'm saying, you can apply, and I'm encouraging you to apply to the Ministry of Justice, Attorney General's Department. You may be given a copy.
I've had the opportunity to see. I've not been offered a copy, so I'll try it.
So at least there's a common ground. Now, the point I'm trying to make is that if one of his concerns about the Attorney General was that he took decisions without consulting the president, and that he used his personal authority to enter this nolle prosequi. But that also shows a certain level of misunderstanding of the Attorney General's powers. And I'm surprised that for a former Attorney General, who also served as a Deputy Attorney General, to diminish the extent of the power of the Attorney General, to suggest that every decision that the Attorney General is supposed to take, he has to go and take direction from the President. Because the Constitution itself is clear that the Attorney General has two sources of. One is those that the Constitution imposes on him, and those that the President may assign him. These are the two, if you read Article 88.
But these are very important cases, significant on our national economy.
You see,
the banking collapse crisis.
You see, the Attorney
How does the Attorney General take a decision without recourse to Cabinet?
The Attorney General's office power is sui generis, okay? When it comes to prosecution, because that is what the Constitution says, that it is he decides who to be prosecuted and who not to be prosecuted, whether to continue the prosecution, whether to end it. That is for him. The President may indicate to him that based on this and this, I am assigning this to you, which is also lawfully under the law. That is why we always say that we need to decouple the Minister of Justice from the Attorney General's authority, because the Attorney General, as Attorney General, is a completely different thing. And as in his capacity as a minister, the President may use that power to assign him some work. But to suggest that if an Attorney General wants to enter nolle prosequi or wants to take every decision, he has to go and take direction from the President.
Before we move away,
yeah.
The Johnson Esiama matter, there were two different cases, not one.
Yeah.
Attorney General Dame says that you also sought to confuse both, as if that even if there was a memo, it's in respect of both. But it does appear it will be in respect of one. Is that not it?
The memo was in respect of one. But that is not the only reason why the memo is not the only reason why the nolle prosequi was entered. So if his concern is that the memo is for one, there are other considerations which the Attorney General outlined, that he has assessed the docket, and in his knowledge and his experience and a professional capacity, he realizes that these cases were not going to land in any successful prosecution and shouldn't have been started in the first place, and some of which Bright has explained. And those cases must be taken off. Now, this brings me to the next issue of calling the whole thing OCAL. There were 7 cases. About 5 of them had nothing to do with looting. So if you say it is operation...
Still, the memo is referable to the...
One of the cases.
The Unibank case.
Yeah.
Then there is the other case where Johnson Asiama is involved, which is about the UT Bank case.
Yeah.
So how come he gets, and
I am saying
a clean bill for both?
What I'm saying is that from the Attorney General's explanation given, he did not just base his decision on one document. He said he has assessed the docket, he has consulted with the prosecutors, and he has also spoken with the defense attorneys. And from where he sits in his judgment, he believes that none of the 2 cases were going to lead to any conviction anyways. And he sees no reason for persecuting or subjecting someone to a criminal trial when he knows in his heart of hearts that this is not going to lead to anywhere. So
Bright has just explained here the question of the violation of the single obligor limits, which is the UT matter, which the memo did not cover.
Yeah, the memo is on there.
That doesn't make sense to him. But Domkain didn't say this to us, like Bright has put it, that the single obligor matter, it doesn't make sense.
So we need to take the press conference in 8 terms. For example, if you take the Ofusu-Ampofo situation, there was no comment on there was no attempt to explain.
Ofusu-Ampofo and Kweku Boahen, right?
Yeah, there was no. So we should not take the press conference as the totality of the things that, because the press conference had to, when you are doing a press conference, you need to consider the time limit and all that. So we shouldn't just take the press conference as the only decision. But I think we should take the Attorney General's word when he said that from his professional position, he has examined all the dockets, he has consulted widely, not just with the department, the prosecutors in his department, but also with defense counsel and even people beyond that. And he has come to the firm conviction that these cases, and there are many more to come, these cases were not going to lead to any conviction.
There are many more to come.
There'll be more cases.
It's unprecedented in our history.
Because you see, we should be
that you are entering discontinuing cases.
It is equally unprecedented that it is.
Imagine that another government comes in the next 4 years, and its members are being prosecuted, and they decide to enter nolli prosequi. What are we making of the judicial system?
What is unprecedented is an Attorney General who has been partisan for all the years that he's in office and has decided, even without evidence, to persecute people. That is what we should be concerned about, not the person who has come to save the situation. I mean, if you put someone in the criminal justice system and you go to sleep for all these years, and someone comes to say that I have examined what you have done, you have no real basis for continuing this, for starting some of this trial.
If the evidence exists, that will not lead to their conviction, and some of the cases are just about to finish, why don't you finish it and allow the court to acquit and discharge them?
That is why I'm saying that.
And it depends on how you... In the Unibank case, the prosecution had closed its case. So the withdrawal means that Johnson Asiama is acquitted and discharged. But in the other one, I'm not sure they closed their case. So it means there's room that in future he may suffer, right?
No one deserves to be put through the ordeal of criminal trial, even for one day, if there's no basis for it. So the fact that they have suffered this period does not justify any attempt to say that
there's no basis. Where the courts, in almost all these cases, the courts have come to the conclusion that they have a case to answer, and they are in the processes of answering their case. So how do you come to that conclusion?
If the court was the most appropriate place to determine this, I don't think the lawmakers would give the Attorney General the power of nolli prosequi. They would have just said that once you start trial, allow the court to go. But in the wisdom of those who design our criminal justice system, they have a reason to give the power of nolli prosequi, which could be exercised at any point in time. That shows that they understood that the yardstick that the courts work with may not necessarily be the one that the prosecutorial discretion will be applying. So we cannot say that asking for nolle prosequi means that the courts are not effective or anything like that. We are just saying that to subject a human being, a citizen, to criminal process. I mean, I'm surprised that we are making this comment. We were here.
I'm sorry, but I have to catch you here. And because we are just running.
Let me make this last point.
Let me go to Frank Davis.
No, let me make this last point
quickly in a minute.
Let me make this
in a minute.
Yeah, in a minute.
Mm.
I mean, so I was saying that to tag this whole exercise as OCAL, Operation what? Clear all looters. It's actually very unfortunate because the person who made this is my very good friend, and I'm just imagining a day where he would be in this system, this unfair criminal trial, and will now be ordered when he's given relief. He will consider himself a looter. I mean, what has Fufu got to do with any looting? What has Ato Forcing got to do with any looting? What has Saglemi got to do? Saglemi was misapplication of the funds. It has nothing to do with looting. Esiama, the evidence shows that the money has been recovered.
But the cases that are being called looting are similar.
No.
Okay, no, Mr. Frank Davis, sorry, Frank Davis, let's hear you on these things and what it portends for the future of our criminal, jurisprudence.
Samson, you have shortchanged me. All of them have spoken at length. If the program is going to end at 12, I have only 8 minutes, but let me try. Samson, I'm very disappointed, and I must confess with some of the things I've heard. My very good friend, the Deputy Attorney General Dexine, say, hey, I'm really disappointed. Because, I always say we are all trained lawyers. Yes, we have political coloring, but when we are discussing certain matters, our sanctimonious fidelity to the law should be paramount. It should be paramount. Justice, we can sit on TV, radio, and say the kinds of things we say.
Because this is personal. So
yeah, but you have the right to reply. Don't worry. You said so many things. You see, when you make judgmental calls on people, you should also hold yourself in readiness for the responses which will come. When you say the former Attorney General, look at the language you use. I don't want to repeat it. You go to the point of saying he's persecuting people, but that is not fair. You don't have the right to judge him that he's involved in persecution instead of prosecution. You don't have the right. Justice, please, with all due respect, you don't have that right. So let's be cautious about the language we use. Look, I'm minded to borrow Bryce Simmons' language, that on this matter is principle. Let's stick to principles. Justice Swemsai, maybe you've been out of this country for so long, but the Attorney General, Dominic, is my very, very good friend. When you go ask him, he knows. I think this is the first in the political dispensation of the Fourth Republic that an Attorney General has involved in this wholesale instance of nolle prosequi and withdrawal of charges against politically exposed persons in this jurisdiction. And it is worrying. And that is what Samson was minded for you to respond. You didn't respond to that. It is worrying, you see, because at the end of the day, any other Attorney General can come and then decide that take it or leave it. When there are cases against politically exposed persons, all those persons will be wiped. Give me one instance of the people who have been wiped who are not politically exposed persons. Justice. You see, when we are talking principles, we should be bold and firm and not stand on quicksand. Because when we stand on quicksand, we will sink. You are talking about the fact that people should be subjected to their personal liberties. Excuse me, criminal prosecution has nothing to do with personal liberties. Nothing at all. Maybe we should all go back to first steps of criminal jurisprudence. Criminal prosecution has nothing. It does not run in tandem with personal liberties. The prosecution has to prove your guilt. That is the burden. You are not at liberty to be suffered at large. No. But when you say the office of the Attorney General is sui generis. What do you mean by that? How can the office of the Attorney General be sui generis? It is not. Yes, it is only the Attorney General whose qualification is called into sharp recourse when that is, no other person than a lawyer can be an Attorney General. Indeed, for all the ministries, anybody else can be a minister. I'll stretch it by saying that maybe the Minister of Finance you need, but there have been occasions that the Minister of Finance has been run by chartered accountants who are not economists, and they have performed very well. But Justice, the office of the Attorney General is not sui generis, if we all understand what is sui generis. And with great respect to the Attorney General is the chief or principal legal advisor to government. These are cases which involved financial losses to the state, whether wrongly or rightly. How can the Attorney General say, Dr. Anyenini, how can you say to Ghanaians that this is your personal responsibility? It cannot be your personal responsibility. You cannot take this decision to enter non-prosecution and withdraw those charges without consultation with the presidency. If you did that, don't do it again. You can't tell anybody.
Is the argument that...
Excuse me. When you were talking, I was quiet, please.
The president approved it. Is that the argument?
When you
all
take
of a sudden
such decisions, you are a senior cabinet minister. You advise the government on all legal matters. Now, if there is this thing, Ghanaians are applauding this government for an operation recover or loot. And then there are persons standing prosecutions in court, and it involves money. Then you go to clear them. Like Samson said, if the Attorney General was definite that the charges that have been preferred will not stand the test of time, why doesn't the prosecution run its full course? The reasons he gave, some of the, excuse me, Samson.
Maybe we'll have a lawyer's file. My time is up. Unfortunate.
Some of the charges were defective. He says others amounted to political witch hunt. Thirdly, the conduct. That is where the conduct of some of the judges left much to be desired.
Yeah, and some of them he was involved and he had taken a decision and he could not, for ethical reasons, continue.
The conduct of the judges left much to be desired, and some of them were promoted. Come on.
He said he didn't mean to impugn them, but he said so. I'm sorry.
Leaving of prosecution to politicians is not going to help us.
Right. And Kofi Bentil says that in fairness to the public, let's say the AGs were doing politics, not law. The law has been used as an excuse for political decisions. My outfit is by Konati Clothing.
Samson, I think
you can call them on 0244 676732. I'm sorry, Justice. People pay for this show. This show is brought to you by Bank of Africa, as strong as a group and close as a partner. MTN everywhere you go. HSC University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, dial *165#. On MTN to join My Way today. DBS Industries, Roofing, Papa Fie, Flamingo Paints, Simply Superior, Syntex Tanks, it's strong, it's tough. Activa International Insurance, our clients, our passion. And the mass sacking matter, we should deal with it at another date, but we see that there is some indiscriminate process that clearly may have to be questioned, because some of the employment or recruitment were done long before December 7, and yet they have also suffered. We have evidence of that. Next week, God willing. Have a good afternoon.